Lordship,
So please don't mention conclusion.
extreme.
I cannot accommodate so many matters in the list. Let me take up.
Non-prosecution.
Leave may be
Suppose same
granted
applies to you.
file.
File it.
It
File
is
it.
case of Jalpaiguri.
Oh.
So, asking to
Leave is
take
granted. That leave is
from-
granted. Yes.
Lordship, this is also matter of Jalpaiguri, Lordship.
Leave is granted. You are asking for leave to file.
Leave to file and to appear, Lordship, because the date of auction is on.
No, leave to file. I always grant. Yes. Leave to
Not for
file.
non-prosecution.
Jalpaiguri matter. Yes.
Non-prosecution.
Hand over. Yes. Call on the list.
To be mentioned item number 1.
অরিত্র এগুলো কিন্তু লিভ টু ফাইল দিয়েছি কিন্তু অ্যাপিয়ার করবে ডিউ করছে হ্যাঁ paid
Yes, my lord.
who you
No, my lord. My lord, the concerned officer has paid by account pay check.
you are still in the panel
Yes,
if you are
my
not Mr. Bandhavadar just tell me
lord. No,
mention in open court and tell me
my lord. Because in this case, my lord, there are no latches on my part.
generally there isn't the matter has already been disposed of full stop it was kept in the list for hearing learned counsel on the question of compliance of the direction of payment of costs full stop a photocopy of a receipt in that regard is handed over in court today which is kept on record full stop since the direction as to costs have been complied with by the WBSEDCL comma no further order need be passed full stop
Great, great.
Top item 2.
But I appear on behalf of the CS. Man.
yes Mr. Mukherjee
Report, man, yesterday I have circulated, man.
For the petitioner.
yes what was the case Shifting.
The case of the petitioner was that the electricity connection,
you are the petitioner
I'm the petitioner,
yes
was being obstructed by the private respondent who claims to be the landlord.
Right.
Since one of the three matters, an eviction suit has been filed on that pretext. The CSC gave me a letter that since there's an eviction suit, we cannot effect the connection right now.
2 3 আর 4 তিনটেই তো লিস্টে দেখাতে হবে অরিত্র একটু বলে দাও 2 3 4 তো একই ম্যাটার ওকে না বললে বুঝবে
2 to 4.
yes
Report was circulated yesterday. Kindly comes to the report. Kindly comes to paragraph number 3.
সব দিয়ে দিয়েছি কালকে যারা যারা ইউ আর নট দেয়ার আমি বাড়ি গিয়ে তো আর দেবো না
no Mr. Mukherjee please explain this initially there was an overhead connection
My lord.
you're also reading for the first time
No. When initially there was overhead connection, they are asked for shifting of the same. We have tried for the shifting.
who has asked for shifting
My lord, the Mrs. Parvati Rajok, the private respondent.
no petitioner was never enjoying any electricity
No, my lord, that not she was not.
he was not enjoying so now he wants for electricity he's a tenant
My lord, we are ready and bidding, man.
you are a tenant
They were enjoying through a sub meter.
there is an existing connection from where electricity can
Yes,
be given.
please, my lord, kindly see paragraph 4.
And Parvati Rajak is wanting a shifting for giving that connection, which is not possible.
No, my lord.
What is 4 about para 4? So at the existing service position, you were willing to give.
Yes, my lord, the existing service.
Parvati Rajak is the landlord. Who is for appearing for respondent, private respondent?
My lord, I am for the state.
Yeah, for the private respondent.
Still in item 4.
2 to 4, nobody is appearing for the private respondent.
They were appearing, my lord.
No, yesterday they were
also
there.
they appeared.
No, we are ready and willing, my lord. Only thing, my lord, if my lord may see, my lord, if there are 3 or 4 meters, my lord, in one existing meter box, there are a box. We
The
provide.
petitioners are different tenants.
Yes, different tenants.
3 tenants might not have applied.
The
So we
3
will-
matters are taken up together for hearing in view of the identity of the causes of action. Full stop. The petitioners are 3 respective tenants in respect of the disputed premises, where the private respondent in all the matters is the landlady. Full stop. Next para. The petitioner seeks an independent electricity connection. Full stop. The CSC Limited is agreeable to give such connection from the existing meter board position, comma, upon replacement of the existing meter box with a new panel board comma, as disclosed in the report of the CSC. Full stop. Next para. It is also evident from the report that the landlady is raising objection to such connection being given and wants a shifting of the existing service, which is not technically feasible according to the CSC Limited. Full stop. Next para. Today, comma, when the matter is called on for hearing, comma, none appears for the private respondent. Full stop. Next para. It is well settled that an occupant of a premises is entitled to electricity connection, comma, if otherwise technically feasible, comma, under section 43 of the Electricity Act 2003, full stop. In the instant case, comma, irrespective of the consent or otherwise of the landlady, comma, the petitioner has the right to get such connection. Full stop. Since the CSC Limited is of the opinion that the same is possible, comma, subject to the modification in the meter box as suggested, comma, the said right of the there cannot be any further impediment in the matter. Accordingly, WPA 14924 of 2023 is allowed, comma, thereby directing the CSC Limited to give electricity connection to the petitioner in the petitioner's name at the existing meter board position of the premises. Full stop. If any modification is required to the existing meter box, comma, it will be open to the CSC personnel to undertake the same. Full stop. Next para. In the event the CSC personnel are prevented from doing so by the private respondent and or her men and agents, comma, it will be open to the private respondent to the CSC personnel to approach respondent number 6 in all the matters, that is the officer in charge of the Cosba police station, comma, for adequate police assistance in that regard, which will be given by respondent number 6 by acting on the server copy of this order at the cost of the petitioner. Full stop. If need be, comma, it will be open to the police to remove any padlock or other hindrance to obstruct the CSC, which might have been put up to obstruct the CSC personnel from giving such connection. No address to cause.
Grateful, grateful.
2, 3, 4, 3. Next.
Item 5.
Yes. What is that, please?
That bifurcation of jurisdiction of marriage.
Your
Oh.
Lordship, I'm appearing for the state.
Mr.
uh,
Galib
Miss-
was to,
Mr.
Mr.
Galip
Ghalib.
was appearing.
I'm led by Mr. Ghalib. He's busy in another court.
Maybe he's busy. You move the matter, ma'am.
Your Lordship,
Every day I cannot wait for Mr. Galip. He may be busy.
Your Lordship, kindly, if you can keep the matter in the next week. In the meantime, I will be getting the instruction from the department.
because my lord,
We haven't yet received. There will be a meeting in this week only in the department.
no,
If
this
your
one-
Lordship kindly,
That's a better ground than Mr. Galip being busy somewhere.
he's also busy in another court, Your Lordship.
Learned Counsel for the state submits that the state requests further instructions in the matter and the matter be adjourned till the next week. So accordingly, let the matter stand over till July 25, 2023, when it will be placed fairly at the top of the list. Thank you.
my lord, in the mail, they will not proceed or
They will not.
proceed with the notice. Because, yes,
The respondent authorities shall not proceed in the meantime on the basis of the impugned notice.
yes. I'm grateful, my lord.
Item 6.
Yes.
I'm grateful.
Thank you.
So,
I appear for respondents 2 and 3 in this matter.
Yes,
My
Mr.
lord, the only prayer which can be granted, my lord, otherwise it would tantamount to disposing of the writ petition. Is
No, let us hear him. Yes. Yes, Mr. What is
it's an election procedure of the Chartered Accountant Institute which has been challenged. If your lordship kindly comes to prayer E, which is at page 22, my lord,
Yes.
we don't have ballot boxes, but we have already preserved the ballot papers.
Acha, very well.
That is the only prayer, my lord, according to me, which can be granted as on tape, that we have already preserved the ballot papers.
Very well. Let me hear Mr. Shamanto, Mr. Bhattacharya, then I'll decide. Yes. Yes, Mr. Shamanto.
Milord,
So will you be satisfied if I direct affidavits and grant D?
Milord, I think affidavits would not be necessary
Yes.
because, Milord, the
Shamanto,
part-
please use the microphone so that
I'm
you can
sorry.
hear.
Milord, affidavits won't be necessary subject to my lord's pleasure because, Milord, the final order has been challenged.
Acha.
There is no appeal provision. This is surprising that the Chartered Institute doesn't have an appeal provision. Now, therefore, your lordship will be only examining that part of the order, whether it has been properly passed or not.
But if it's a final hearing, final order, Mr. Samudri, it's
My lord,
all the more necessary for a-
may I show your lordship, subject to my lord's pleasure?
Absolutely.
My lord, lordship will kindly come to your lordship's own order, my lord. At page 209 it starts.
Yes, yes.
What happened, my lord? We preferred the writ petition challenging the delay in deciding the matter. The writ petition was slated to be coming up before my lord on 9th. The moment they get notice on 7th, they pass the final order. In hurried haste, the order was passed on the hearing was done on 27/9. 27/9/2022. We made several representations. Kindly pass the order. Kindly pass the order. Nothing was done, and then this hot haste in issuing the order, my lord. Now, my lord, therefore, your lordship, the first writ petition became infructuous. But only your lordship granted a prayer that the ballot papers should not be. Now, my lord, lordship will kindly come to the order impugned. Because, my lord, why I'm saying this, lord? Mahendra Singh Gill, my lord. An order cannot be sustained by any affidavit, supplement, etc. It has to stand on its own feet, lord. Now, my lord, lordship kindly comes to the order. That order is, lord, it starts at page
197.
197,
Right.
and the relevant portion would be 206.
Yes.
We have considered the allegations made by the petitioner in his complaint received dated 21/2022. But before that, I'll just show your lordship one thing. Lordship sees the order was issued on 7th June, page 196, Lord. Kindly sees. June.
Yes.
Now, my lord, kindly comes to the next page.
Hmm.
Order. Then this petition was heard by us on 30th September. Even this is wrong, my lord. It was heard on 27/9. Lordship will see the extent. Why I'm saying, my lord, your lordship knows the extent of hurry in passing an order, to the extent that three officers, they issue the order where even the date is wrong. What does it imply, my lord? Your lordship knows better than me.
It implies that they're like me
No, my lord.
regarding the dates being wrong. I can identify with that.
My lord, then my lord kindly comes to page 206.
Yes.
Fourth line. We are of the view that the original complaint made by the petitioner within the time frame for filing an election dispute and additional grounds submitted by the petitioner much later have two different complaints. My lord, I join issue over here. The complaint was originally that the election dispute was for the purpose that a person had sent emails to different persons of a current standing that they would be voting by ballot, by post. Now, subsequently, when we made the complaint, we didn't have a particular document before us. The document was from Bhubaneswar, RTI was made. I'll take your lordship to the RTI, lord. Lordship kindly comes to the RTI. Or rather, the additional grounds, lord, I have raised. Lordship will kindly look at that. Page 88, lord. My lord, why I'm troubling your lordship, my lord, is this. Because in the event your lordship finds that the order is inappropriate, your lordship will not be deciding anything. Your lordship will have to remand it back. And if remanded, my lord, there has to be a new election body, a tribunal for this purpose, because the election tribunal is functus officio after 15 days. That rule I'll show your lordship. Now, my lord, the additional grounds. Lordship kindly come straight away to page 90.
Yes.
RTI application was made by the applicant on 21st March. Not 30 days is the time within which the election dispute has to be raised. I raised it within time. I didn't have RTI because RTI takes 30 days.
Additional grounds was also filed within that period.
No, additional grounds has to be after that because I got the RTI document
Right.
and then only. RTI, my lord, 30 days minimum.
Challenge was preferred in time.
Yes. Now, my lord, the said RTI reply states, paragraph 2, that the ICI personnel who was deputed for election duty in Bhubaneswar reached Kolkata with the ballot boxes on 6th December evening and not 5th December afternoon evening, which would have been his normal course of action as he had in his possession sensitive material, ballot boxes which should have reached the strong room of the Cosba office at the earliest and kept safe and secure for counting.
But here I join issues. We do not have ballot boxes. It's only ballot papers.
Very well, Mr. Bukha. Mr. Bhattacharya. Yes.
But how can it be that they have only ballot papers? Because boxes were sealed, boxes were taken out, and they have to keep it
They
inside.
put it in files probably. Yes.
That the applicant was present at the strong room on 4th December 2021 evening to observe safe arrival of the ballot boxes where polls were held in and around Kolkata. On inquiry, the DCO head CA informed the applicant that all ballot boxes from outstation polling centers would definitely reach Kosba strong room latest by December, 5th December. My lord, instead of that, it was 6th December that it reached. Such conduct behavior by the said staff raises serious suspicion, doubt in regard to his role vis-a-vis the ballot boxes in his custody, which are inter alia as below. Now, my lord, the next page, Lordship sees paragraph B, that holding of examinations and elections are very vital and zero tolerance, and this act of said ICI personnel falls under the ambit of grave and severe misconduct, which requires thorough forensic investigation by an appropriate specialized competent authority, either the police authorities of West Bengal and Odisha Ministry of Corporate Affairs, etc., which the Honorable Election Tribunal may deem fit and proper, and the report of such investigation placed before the Honorable Election Tribunal. The applicant may also kindly be allowed a copy of such. But this was our mainstay, that someone has been benefited because of this act, and therefore an investigation was required. It was made clear on the day when the final hearing on 27/9/2022 that kindly direct some authority to inquire into the matter. Instead of doing that, they sat tight over the matter. And then your lordship kindly comes back to page 206, Lord, that they are saying that it's too different. An entire action is saying that they two are different, therefore there is no cause of
So
action.
your allegation was primarily that it reached one day later.
1 day later. And if your lordship sees,
And it came by road instead of flight.
yes, my lordship kindly comes to page 91,
C,
C, then D,
right?
then E. The particular gray area which requires to be considered and the light of investigation shone on commences from handing over of the ballot boxes to the said staff and the journey of the ballot boxes, as the case may be, to the strong room of the institute, and obviously on a finding of forensic investigation of anything different from the normal, the mens rea and a beneficiary thereof. But without this investigation, the entire action is suspect.
Why do you say this is illegal? Handing over to the staff? There has to be some modality of handing over and sending the. It was handed over to one staff, such and such data entry operator. So what is the wrong in that?
No, it was not the. He was keeping the boxes. He was there in Bhubaneswar. He had continued to be there for a long period, and the boxes were with him for the entire period. That part is suspect.
But why should we assume? Why do we presume that there was any false play?
Milord.
Any person may have been in possession.
No, not that. Milord, I'm.
It reached 1 day late. It came by car or bus or whatever, by road. So what is the wrong in that?
No,
I
no,
mean,
no.
why should he assume that there was some false
No, no,
play?
no. Milord, the thing is that we have subsequently also shown our written statement before the tribunal that the entire action was such that it was suspect and therefore there should be an investigation.
You are being paranoid, Mr. Shamantu, your client.
No. Milord, I'll show your lordship what was the thing. Milord, your lordship kindly comes to the RTI document which was given.
I can indicate what was his grievance. He said a particular
Yes.
community.
You are also being paranoid, Mr.
No,
Bhattacharya.
he said a particular community was supposed to vote for me. That was his entire grievance.
Might have been right. So let us hear Mr. Samanta first on that. Let us see how Mr. Samanta veils that submission.
Well,
Yes, Mr. Samanta?
Milord, we are coming back to that part, Milord.
Yes. The particular community that I anticipated when that's why I saw the constant. But that may be a paranoia also.
Milord, probably
So
not
Samanta,
here.
this is because I have to belong to that community for the time being until I hear out the matter against you.
That's right. That's right.
Against you
That's right.
to decide the matter.
Milord, Lordship kindly comes back to page 90, paragraph 4, Milord.
Right?
Paragraph A then, next page. Return of the ICI personnel on 6th evening and not 5th afternoon evening raises serious doubts as to what he was doing for so long in Odisha with the ballot boxes. There is every possibility that the said ICI personnel may have manipulated, tampered, changed the ballot boxes in
Mr.
connivance.
Samanta,
with-
you have to work as hard as the other community. That's the only solution. You
No,
have to
but-
work as hard.
Milord,
So you will also be elected then.
Milord, what
But this, I don't find any irregularity in this.
Milord, what I would
For
submit.
the read code to interfere at least,
No,
no.
no, Milord. That's why I said, Milord.
Even for that
There-
authority to
if
interfere.
there
Why
was
is the presumption?
If there
coming
was
at
an
all?
appellate authority, I would have had the advantage of
True, Mr. Samanta. I'm not saying that
Now,
read
Milord-
code for because questions of facts are involved. I'm not saying that.
that's right.
But there has to be something on record which shows palpably that yes, there was a violation of the norms or there was some irregularity which
There
stares
is.
at the face.
Milord, there is
It reached one day late. It
no,
came by
not
road
because of that.
and it was handed over
The
to a detained
boxes,
operator.
Milord, the car which was kept with them, it was there continuously for 5 days. The RTA document shows that. That shouldn't have been. Lordship
The
will
change
kindly
of
come-
cars would benefit somebody.
No, not change of cars, Milord. Keeping a person, Milord, may I show that
Yes.
part, Milord?
If he did not leave the car, then how could he manipulate?
No, he has to leave the car because he's staying at a hotel also. He's
Obviously.
keeping the car.
So keeping the ballot boxes in a particular car, that's
What
the thing to be done actually.
What I'm trying to make
Yes,
my
Mr.
point,
Samanta, I
Milord,
can't understand.
is this, Lord, that a person entrusted with the ballot boxes,
Yes.
he is supposed to have complete
Isolation.
and everything. Not doing that and keeping it alone continuously for a certain period of time, Lord, that is against the tenets of, that is one. Now, Lordship sees,
What about the antecedents
Lord-
of that person? Is there anything to show that that person is corrupt otherwise?
no, page 94, Lordship kindly comes.
Yes. 94.
Information received from the concerned department, the RTI, my application.
Right.
In reply of point number 1, it is informed that data entry operator was deputed for election duty and his official contact number is this. With regard to his residential address, there is nothing. It is informed that copy of the hotel bills, so where he stayed for the period from 1/12 to 6/12 are enclosed. In reply of point number 3, it is informed that as per records, he stayed for 6 days, including up and down Kolkata. In reply of point number 4, it is informed that he traveled by car from Kolkata. As per records, he left from Kolkata on 1st December at 4 and returned on 6th December at 10:30 p.m. Copy of the bill, etc. The details of travel agency, driver, name, contact number, and total kilometers traveled are given below. Lord, this itself is never done. That is why we had made that question that how this could be done in this way. Sending a person there uncontrolled, unchecked, no other.
Mr. Samant, let us see how the authority dealt with this. Let us
Sure.
come to page
But
206.
before that, would your lordship kindly take page 175? What is his complaint? Page
Com-
170.
Complaint has been referred to in page 206 and 7.
Yes, 206, we have dealt with it, but your lordship kindly sees his complaint. Why? His basis for arriving at this apprehension,
100.
175. That's a part of this complaint. In other words, I'm sorry, madam.
Yes.
In other words, getting 431 transferable votes by candidate serial number 2 against 293 transferable votes secured by candidate serial number 3 is totally different from serial number 5. Not only the output of ballot box of Bhubaneswar on first day is an impossibility, as Odia voters, after voting first preference to candidate of their own state, would normally cast their subsequent preference to a Bengali candidate as per their general practice and general trends in earlier election. This is his entire edifice of his case, and this has been dealt by at page 206.
Samant, I'll request the Chief Justice to assign this to Justice Sharaf.
As your lordship, I have nothing to say.
No, there's the no ground. Let us see how they dealt with it.
Lordship sees
206, your lordship will carry absolute reasoned order.
Indicate from the inception I've seen at the outset.
Hmm.
So Mr. Bhattacharya need not be apprehensive on that.
Paragraph 4 at 206.
Let him place his case, Mr. Bhattacharya.
Well.
Yes, Mr. Samanto, please.
Lord, fifth line. The first complaint made by the petitioner is regarding wrong mail sent by the respondent to specific members, and the same is directly related to the respondent. The proof submitted along with the allegation, the written statement and oral submission made by both parties also indicates that the complaint made by the petitioner is directly related to the respondent who is contesting in Central Council. White ballot number 2, and the petitioner was also contesting the same election, white ballot number 3. The additional grounds submitted by the petitioner are about his apprehension of some malpractice done by one of the ICI staff and in connivance of the person who would benefit from the act. The additional grounds should be supportive of the original complaint, in which more evidence, proofs, witness, or such papers or facts are provided to strengthen the allegations made by the petitioner in original complaint. But it is found that in additional grounds, the petitioner has diverted the issue. Lord, I fail to understand where we have diverted the issue. Because if this is the basis of rejection, Lord, then Lord, the entire exercise becomes infructuous. Election dispute cannot be dealt
Let
with.
us see the rest. Yes.
Now, Lordship kindly sees. The additional ground should has diverted the issue to a different complaint, which is just an allegation without any proofs, evidence, or papers that establishes its connection with the original complaint or the respondent. That is why we asked for an investigation. How can we get the entire documents? The very basis of such a complaint is that this happened. We have got an RTI and then this happened. Therefore, we are asking for. No, therefore, I cannot provide all the evidences. If I could have provided all the evidences, it would have been an open and shut case.
Will kindly see paragraph 4 at 206, how it has been dealt.
Sorry, I'm in 207.
I'm sorry. I'm sorry.
The respondent has accepted that he sent a wrong mail, etc. He accepted the entire thing. He couldn't controvert it. The needle of suspicion points to the act, Lord. And it is not that the tribunal did not find mistake on the part of the respondent. It did find it.
Yes, Mr. Bhattacharya, give me two explanations only. One is, why do you say that the wrong sending of mails, the mails were sent by he was one of the officials who was in charge of the elections also?
No,
Or
he was one of the contesting. My lord will kindly come to.
Clearly as a candidate.
Yes,
It was in the capacity of a
my lord will find it at page 207, last line.
Bhattacharya, I've seen it that he was a candidate, but he was a candidate. Simplicity does not establish that he sent it in the capacity of a candidate. I'm asking you whether
He was not an officer. He was not an officer.
So very well. As an office, as a candidate, he sent wrong mails. That is one aspect of the matter. The other aspect is, why did this person, the data entry operator, keep it for 5 days? I mean, please come to page 175. Not even 175 prior to that. This was dealt with somewhere.
Your lordship is saying modus operandi, page 173.
Maybe. No, the transit time was normal from Bhubaneswar to Kolkata.
Yes, my lord. Yes, my lord. That's what my instructions
When did
are.
he set off from Bhubaneswar?
My lord,
When did he start off from Bhubaneswar?
my lord, that I have to take an instruction on this.
Is it indicated somewhere? I mean,
I'll just check that. My lord,
Samut, according to you, what is the time lag?
My lord,
my lord, these are kept in sealed ballot box provided by Election Commission of India. It cannot be
There are
tampered
no
with.
boxes? You said there are no boxes.
No, the boxes. I'm sorry, my lord. The boxes are not preserved. Once the election is over, the ballot papers are preserved. The boxes are returned.
my lord, kindly comes to page 175. Your lordship is right, page 175. Second last paragraph. The ballot box with the forged ballot papers were interchanged, most likely somewhere between Kolkata to Bhubaneswar, as the ICI representative was traveling by road. Either they met on their way on 6 December.
Yes, he stayed between 1st December to 6th December. Mr. Bhattacharya, this is somewhat suspicious. Why should have stayed off for, say, 5 days somewhere in between Bhubaneswar and Odisha?
That I have to take instruction.
Only
But
on
your
the-
lordship kindly comes to page 207, how the tribunal has dealt with them.
Other points have been dealt with quite adequately, Mr. Bhattacharya, but about this point only satisfy me. Because page
Kindly take the last portion of page 206, last line.
106, yes.
Further, as inquired from the office, the printing of ballot papers is a specialized job and done by security printer only. There are multiple security features which are known to one or two officers only, who are managing the printing in a very secret manner. Out of the total security features, that are some which cannot be copied. At the time of counting, the security features are informed to counting teams so that any duplicity cannot. The further ballot boxes are special boxes taken from Election Commission of India, which have a specialized locking system with a seals. Once it is locked, the opening can be done only by breaking the original seal signed by the polling officer and the candidate's representative if present. He could have been present when it was opened in Calcutta. It cannot be tampered with. During the counting of votes and at the time of opening of ballot boxes, the counting thing shows the ballot boxes and its seal to all available candidates or to its representatives to check. He could have been there.
Very well. Yes, Mr. Bhattacharya. Mr. Samanta, I won't interfere in this. Learned counsel for the petitioner points out that the impugned order whereby the respondent authority dealt with the complaint raised by the petitioner regarding the elections of the Institute of Chartered Accountants of India, suffers from several irregularities. Full stop. It is, first, submitted that the petitioner raised various objections which were not dealt with adequately by the respondent. Full stop. Next para. It is learned counsel places particular reliance on the within double inverted modus operandi of the election process, comma, and the election process and the counting, comma, which was pointed out clearly by the present petitioner, but not dealt with by the respondent authorities. Full stop. That apart, comma, several additional grounds were taken by the petitioner, comma, which were not considered by making a proper inquiry by the respondent authority. Full stop. Next para. As for example,
Election tribunal, not
আচ্ছা
respondent.
রেসপন্ডেন্ট অথরিটি না করে রেসপন্সিবল অথরিটি দ্যাট ইজ দ্য ইলেকশন ট্রাইব্যুনাল. Full stop. Next para. As for example, comma, it is submitted that the postal ballots were, comma, contrary to the norms and defying common sense, comma, were brought to Kolkata from Bhubaneswar, comma.
No, not postal. They are postal ballot, no. That
No,
was
not postal, I'm sorry, ballot boxes, postal ballot boxes brought to Kolkata from Bhubaneswar by road, comma, instead of by flight, comma, despite several such flights being available. Full stop. That apart, comma, the ballot boxes were detained for about 5 days in transit, comma, without any probable explanation for the same. Full stop. Next para. An office bearer was entrusted with the transit of the ballot boxes. Full stop. However, comma, it does not appear that there was any further security to keep any checks and bounds on the said officials, comma, which vitiates the process of the election itself. Full stop. Next para. Learned counsel further points out from the additional grounds taken by the petitioner that one of the rival candidates of the petitioner had issued emails to several of the voters, comma, thereby misguiding the said voters to the effect that the vote would be done by postal ballots, comma, contrary to reality. Full stop. Such misguidance of the electorate, comma, it is submitted, comma, also tantamounted to malpractices in the election process, comma, which was also not inquired into by the tribunal. Full stop. Next para. Learned counsel appearing for the you are appearing for which respondent, Mr. Bhattacharya?
3 and 4.
Respondent numbers 3 and 4 submits
2, 3
that
and 4, my lord. Instead of
numbers 2 to 4 submits that the premise of the allegations made by the petitioner was of a communal nature. Full stop. It is pointed out from the tenor of the allegations that the petitioner was of the view that the voters of Odisha ought to have voted first for the candidates from Odisha and, comma, as a second priority, comma, for Bengali candidates such as the petitioner, comma, instead of a third community which got the maximum number of votes. Full stop. Next para. It is submitted that the same cannot be a valid premise for challenging the election process. Full stop. Next para. That apart, comma, learned counsel for the respondent numbers 2 to 4 places elaborate reliance on the impugned order itself, comma, which dealt with all the allegations and the relevant considerations extensively. Full stop. Next para. As such, comma, it is submitted that the writ petition ought to be dismissed. Full stop. Next para. Learned counsel, upon hearing learned counsel for the parties and carefully scrutinizing the nature of the allegations, comma, it transpires that the tribunal elaborately dealt with most of the allegations. Full stop. The only allegation which was not dealt with specifically is that the ballot box with the allegedly forged ballot papers were interchanged most likely somewhere between Kolkata to Bhubaneswar, as the ICAI representative was traveling by road. Full stop. It was also alleged that either they met on the way on December 6, 2021 and ballot boxes were exchanged, or the swapping of ballot boxes could have been carried out in any of the hotels at Puri and Stroke or Bhubaneswar, where he stayed between December 1, 2021 to December 6, 2021. Full stop. The said stay of the representative of the ICAI with the ballot boxes for 5 days prior to reaching Kolkata has apparently not been explained. Full stop. Next para. However, comma, upon considering the entire perspective of the allegations, comma, it transpires that the nature of the allegations only reflect the baseless paranoia of the petitioner, and the allegations made are not premised on solid grounds. Full stop. Next para. Moreover, comma, the tribunal has dealt with the allegations and has observed that the assigning of duty to a person handling the ballot boxes, comma, mode of travel, comma, schedule, comma, receiving the material back in strong room, etc., are the responsibilities of the ICAI, and it has nothing to do with the respondents. Full stop. The apprehension raised by the petitioner that the ballot boxes and the papers were changed by 2-3 persons, comma, as observed by the tribunal, comma, is based on the fact that the transfer of votes from a candidate from Odisha has not gone in favor of the petitioner as was expected by him. Full stop. The petitioner's expectation that a particular community should have voted in his favor, comma, but after the counting of the results, he has found that the transfer of votes was not as per his expectations, comma, was not held to be credible by the tribunal. Full stop. Next para. The tribunal also went on to observe that it is hard to believe that in case if preference would have been changed in the ballot boxes, in the ballot papers by the respondent, comma, he would have given it number 1 to himself and not to 2 or 3. Full stop. Further, as inquired from the office, comma, the tribunal observed, comma, the printing of ballot papers is a specialized job and done by the security printer only. Full stop. There are multiple security features which are known to 1 or 2 officers only who are managing the printing in a very secret manner. Full stop. Out of the total security features, comma, there are some which cannot be copied, comma, it was observed by the tribunal. Full stop. What catches the eye particularly out of the observations of the tribunal is that the ballot boxes are special boxes taken from the Election Commission of India, which have a specialized locking system with a seal. Full stop. Once it is locked with a seal, comma, the opening can be done only by breaking the original seal signed by the polling officer and the candidates' representatives, within bracket if present, bracket closed, full stop. During the counting of votes and at the time of opening of ballot boxes, comma, the counting team shows the ballot boxes and its seal to all the available candidates or their representatives to check. Full stop. Only when there is no objection raised by anyone, comma, the ballot boxes get opened. Full stop. Next para. In the present case, comma, there is nothing on record to indicate that the petitioner or his representative was prevented in any manner from being present when the ballot boxes were opened. Full stop. There is also nothing on record to indicate that, comma, at the relevant point of time, comma, any specific objection was raised by the petitioner or the petitioner's representative. Full stop. Hence, comma, it cannot be presumed on the flimsy allegations made, comma, that there was a false play in the opening of the ballot boxes. Full stop. Since the ballot boxes containing the ballot papers were sealed, comma, which was opened only in due process, comma, no such presumption can be attributed to the election process to vitiate the impugned order of the tribunal. Full stop. As such, comma, there is no scope of interference in the present writ petition. Full stop. Accordingly, WPA 16252 of 2023 is dismissed on contest without any order as to cost.
Lord,
Sorry.
one more thing.
Yes.
Lord, there is no appeal provision. Would it be your lordship's pleasure to make a observation to that effect? Because otherwise, Lord, what happens is we don't have.
Need not, Mr. Samanth, if you challenge on that ground, then it will be you who will be challenging who has submitted, who has filed the petition.
No,
So
not
that safeguard need not be there.
because it's a final order, 10B. It's a final order.
26 always.
Not
They did
because
not
of-
take the point even.
No, I took the point.
They did not take the point. You are the writ petitioner.
No, that's right. But because there is no appeal provision, the result is, Lord, your lordship can understand.
No, I
well understand.
never said that there are detailed questions of facts which have to be gone into. That is not a ground of refusal. I have taken, entertained the writ petition and decided on it.
Lordship. We'll have to write to change this system. Because otherwise, Lord, it really is a failure. Because if you have to come
You have to
the
work harder, Mr. Samanth. That motion has to go. That is one of the main reasons.
Fixed matter, item 7.
Yes.
Yes.
7, yes, Mr. Nag. Oh, that.
Before my learned senior friend starts, if your lordships kindly permit me to place to rely upon two judgments, my lord.
If Mr. Dotto
The
permits.
point I have argued in support of that two judgments, my lord.
কালকে বলে দিলে পারতিস তো, দেখে আসতাম।
Yes, he could have become prepared on
One of the judgment has already been dealt by the learned CJM of the Gujarat High Court in the impugned order. The earlier order which was passed at I have shown to your losses as page 55. There page 58. This judgment has been dealt with on an earlier occasion. When on this ground, the earlier application was rejected. Page 58. This 2009 ACC Online Gujarat 10656. This has been dealt in that because relying upon
Right. That has been extensively quoted also.
Yes. So that
So if you are relying on paragraph 6 of
Yes,
that
yes.
judgment, that is
Yes,
there
yes,
in there.
that. And one more judgment, my lord, of the Honorable Supreme Court,
Yes.
which says the scope of section 14, so far as the magistrate is concerned. Only one paragraph, my lord. Paragraph 25.
Citation to
2013, volume 9, Supreme Court cases.
Novel Kumar.
Novel.
2013 9 SCC 620.
Yes, 6.
Yes. Which para, Mr. Nag?
Para 25. My lord. The satisfaction of the magistrate contemplated under the second provision.
Litigants are probably more immortal than judges. Their names prevail. You remember Noble Kumar, but not the judge who delivered the judgment. Do you remember? Anyway.
Fact, my lord.
But you remember Noble Kumar. Yes. Para 25, right?
This may I please, ma'am. The satisfaction of the magistrate contemplated under second provisos to section 14 subsection 1 necessarily requires the magistrate to examine the factual correctness of the assertions made in such an affidavit, but not the legal necessities of the transaction. It is only after recording his satisfaction the magistrate can pass appropriate orders regarding taking possession of the secured asset. So whether the secured creditor has any right or interest doesn't have the power to adjudicate. It can only find out like whatever has been declared before the magistrate to find
But
out the
magistrate
correctness.
did precisely that. Magistrate says, magistrate squarely did that actually. He did not go into the legal niceties. He said that the certificate only contains description of the property, immovable property. I did a wrong in passing directions regarding immovable properties also. So it's not there on record. By citing this judgment, Mr. Nag, you are ensuring that the court goes against you. Because I'm telling you why. Here the magistrate did precisely the same thing. You are arguing on law. Magistrate was not to go into the legal niceties of the transactions. No.
Right.
Magistrate is to see what is the certificate, what award has been passed by the tribunal, and to execute it, rather pass section 14 order. Magistrate says only this was the schedule, the immovable property. There was nothing.
That is based on the demand notice issued under
Demand notice
13.
So you say the demand notice also cannot be looked into by the magistrate. Do you say that?
No, 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 no.
But that was there only everywhere. Everywhere the schedule contained only the immovable property.
only the can adjudicate the
It did
rights.
precisely that here. Why is this beneficial to you?
It can the magistrate can adjudicate the right of the parties.
Did not. That is what they are saying. He cannot do that. So your argument cannot be taken note of by the magistrate. You are arguing on legal niceties. And the Supreme Court says, but not on the legal niceties. Magistrate to examine only factual correctness of the assertions. Factual correctness says yes, schedule says only the immovable property. No movable property, no hint of that. So I am going by factual correctness. I cannot go into legal niceties, whether those include movable properties or you had a demand for that. That is for the tribunal to decide. So I passed a wrong order, I am recalling that. Why shouldn't that be the law?
But the power of recall is not there. That power of recall is not there. That's why the division bench of the Gujarat
That
High
you
Court
have
has.
cited, yes, that you have cited and you have argued also on law. But that is a legal nicety. Which the magistrate could not go into, Mr. Nath. Remember that. This will be very useful in this judgment also. Yes, Mr. Datta. Do you want to cite any other judgments? Don't. Yes, Mr. Datta.
Yesterday, I made my submission that the entire securitization action was based on the immovable property. The securitization action was not in connection with the movable properties.
Yes.
No dispute on that. Now, my lord, today, my lord, with the other things, the schedule and etc., I have already placed before my lord, my lord. Next document that I wish to show to your lordship is what was the conduct of the bank and as to how bank understood the initial section 14 order. Please have a look to my lord, page number 52. Where the section 14 order is dated 6th of January 2023. 27th of March, that is at page 29th of March, bank writes to us.
Sorry, please give me the page again.
Millard, this is page 52.
52, yes, yes. Got it.
I'm sorry, the seal bailiff. I'm so sorry. The seal bailiff writes to us, kindly take me the first paragraph. With reference to the above, this is to inform you that as per the direction of the learned Chief Judicial Magistrate, video order dated so-and-so, the undersigned is requested to vacate the below mentioned secured asset on or before so-and-so and shift all your movable properties from there, as I will take possession of the said properties and hand over the same to the authorized officer. Now then kindly take me, lord, I go before the tribunal. The tribunal, my lord, does not grant an order of stay. Then, my lord, I make an application on 24th of May. Please have a look to page 61.
Which item is Mr. Banerjee's?
Probably next one.
Next one. Yes, Mr. Datta, finish quickly.
Millard, 24th of May 2023.
Yes.
Millard, please take, Millard, the second last paragraph at that page.
Yes.
As such, at the time, this is my letter. At the time of preparing the inventory of the movables and while taking possession of the aforesaid immovable properties, you made a commitment in front of all concerned that you will return all our movable articles and or the items as per the inventory list as and when required by me. I therefore request you to kindly make necessary arrangement to open the lock of ground floor, so-and-so floor measuring such and such, situated at such and such, phase-wise basis, at least 3 to 4 days as per your convenient date and time, so that I can remove and shift my movables articles and or items more specifically described in the inventory list. Millard, this is my letter, Millard. Then please take, Millard, page number 63.
Yes.
Now, Millard, the bank writes to me in response, subject is removal of movable articles described in such and such. My letter is quoted. Then please take me page 64, the first 3 lines.
Yes.
We have received your letter, so-and-so, received on such and such, wherein you have requested ABFL to allow you to vacate the movable articles goods which are lying at the below mentioned premises. Now, please turn the page. It is pertinent to mention that on so-and-so, you along with your main agent, resident representative of such and such, for conduction of valuation at the above mentioned secured asset, and hence you are requested to extend your cooperation in allowing the representatives of ABFL to conduct the valuation. Kindly note that ABFL is inclined to conduct the valuation and removal of the movable items considering your request from so and so, and you are requested to ensure your presence on the above mentioned date and time for removal of the movable articles, goods articles from the secured asset. Kindly note that you have to bear in the cost, etc., and sign the. So this is all how Millard, both the parties have understood the order of the order under section 14. Now, Millard, there is a change of stance of the bank, which your lordship would find, Millard, from the next page. First line, they recall. This is to bring your under your kind notice. We are hearing, recalling our reply dated 29th of May, issued to you, your good self, on behalf of Aditya Birla Finance Limited, and regret for the inconvenience caused thereby. Then, Millard, please turn the page. Made all the other things, hypothecation, etc., is stated in the first 3 paragraphs, and the 4th paragraph, accordingly, our permission for removal of the movables granted to you, video letter and email, are hereby withdrawn and revoked with immediate effect. It is our humble request to kindly not to disturb, restrain, etc. So, Millard, both the parties understood that, and quite logical, since movables, Millard, were not part of the securitization.
Mr. Datto, the inventory was done in your client's presence.
Yes.
In your presence.
Yes.
Those are still lying there in the property.
Yes, yes.
And what is the power of review of the
Yes.
Millard,
Millard,
recall or review?
yes. On that, Millard, your lordship may kindly have a look to section 14, subsection 2. But I am emphasizing over and over again, movable is not part. Now, please take subsection 2. For the purpose of securing compliance with the provisions of subsection 1, the Chief Metropolitan Magistrate or the District Magistrate may take or cause to be taken such steps and use or cause to be used such force as may, in his opinion, be necessary. Millard, may I say this, Millard? If I have understood this subsection correctly, then, Millard, it can be read into this statute that for the purpose of section 14.1 or compliance of orders under 14.1, some steps as may be necessary can be taken.
So compliance, taking steps for compliance also includes rectifying non-compliance.
Yes.
By overaction.
Yes. No, I won't say overaction, but this gives the power.
This gives the power initially.
Yes.
Suppose that was not done.
Yes.
Apart from this, the immovable property, the movable property was also taken.
Yes.
So now by this present order, that has been recalled virtually. Now it has been said that no, the movable property has to be returned. If that be so, that would be in effect a rectification of the overaction by the magistrate under 14.2.
Could I say this, Millard?
At best that, yes.
Could I say this, Millard? If we come back to, Millard, this order at page 40, 58.
58, yes.
But here, Millard, in the first order of 4th of April, at the middle of that page, the learned advocate for the secured creditor has raised strong objection, submitting that after disposal of application under 14, this court has become functus officio.
Exactly, yes.
Now, Millard, this point, Millard, whether it has become functus officio qua, Millard, section 14, subsection 2, Millard, will fall for your lordship's consideration. Millard, may I read, Millard, 14.2 once more?
14.2 has already been done.
Yes. No. Cause, take or cause to be taken such steps and use or cause to be used such force as may, in his opinion, be necessary. Now, Millard, this step.
If this was taken initially, Mr. Datto, you might have had a point there.
Yes.
That the immovable property is taken and the movable property is directed to be returned.
Yes.
I can understand up to that.
Yes.
But here, what was done was that was directed to be handed over.
Yes.
After that, that is being recalled. So whether that power vests with the magistrate.
Millard, please take, Millard, the order of.
Wrong. He did it wrong according to you.
Yes. Please take, Millard, the order of dated 6th of January at page 45. This is the initial order.
Yes.
My lord, page 50 is commissioner appointed. Page 51, my lord, I had drawn your lordship's attention yesterday.
Yes.
Top. The
Right.
court commissioner to take such steps and use such force, including breaking open of lock or any hurdle thereof, by taking assistance of police if required at the expense of the applicant, and if any article, documents are found in the secured asset, then deliver its possession to the authorized officer of the petitioner after preparing the articles and making inventory. So it was directed to be given to the authorized officer.
So you say this is a further step.
Yes,
Now it's a further step.
further step.
That is not being reversed.
That is not being reversed.
After that, as a logical,
Yes,
I mean,
Yes.
follow-up, it is being handed over to you.
yes, this
So
being
it's a
handed over-
continuation of.
Yes, this is a continuation.
Right.
But I would, my lord, spoken to my clients, my lord. I will not, my lord, come before this court with a, my lord, illogical, my lord, proposal. But what I propose today is, whether rightly or wrongly, the hypothecation is there.
Cannot be transferred, dealt with.
Please, my lord, permit or my lord, direct a complete inventory to be made so that of whatever is lying over there.
That has already been done. Why should you
That,
disbelieve that?
to that, my lord, we have objection because that has been done, my lord, in the understanding that everything is to go to the authorized officer. And that's why, my lord, I trouble your lordship with those letters.
But the articles do not change by that.
My lord, the articles in my it's my client's.
That cannot be reopened.
My lord, it's my client's instruction that a proper inventory, because initially there was an inventory. What we require to know today is what is lying in the property today. I can, my lord, enforce my right. The bank can enforce its right, whichever manner they require tomorrow. But, my lord, the fundamental argument that the bank, the magistrate has become functus officio, possibly, my lord, in the background of section 14 subsection 2 may not be, my lord, a correct proposition or understanding of the statute.
So what will be the occasion to direct a further inventory? I mean, then you have to argue that the previous inventory is vitiated for some reason, which is never pleaded or proved by anybody.
My lord, today, please consider one thing, my lord.
Yes.
The bank is under the impression that it's my property.
They would do a better inventory then.
Therefore, my lord, I want a better inventory to be done so that whatever is there, I'm not taking it out right now.
Mr. Datta, further inventory may not be directed. There is no scope for that, no occasion for that also. Because no challenge against the inventarization or nothing is there on record to vitiate that.
My lord, in that case, my lord, kindly consider, my lord, whether, my lord, this order is fundamentally wrong or not, which has been challenged before this honorable court. But I would be very respectfully submitting two things. Number one, the first order is clear that the movable should go to the bank. In my understanding. But, my lord, both the parties understood that movable should also be returned to me. Thereafter, bank feels no, the movable should not be returned to me. It should remain with the bank. To that, my answer is that bank had the liberty to invoke securitization for the movables as well. They did not do.
The effect of the previous order prior to your order, the present impugned order, was that it would lie with, in the said premises, in the immovable property, under the aegis of the authorized officer.
Yes.
Under his control. So that was the last position. Now what has been done, that has been changed by the district magistrate, directing it to be handed over to you.
Yes.
So handing over to you is not possible at this stage, Mr. Datta, because of the reason that would probably be, unless you win the writ petition, obviously, if you get that, very well, that is also an option.
Yes.
It has to be maintained then, the order has to be maintained.
Yes.
Or otherwise, the second option would be to keep it as it is, but it would not be disposed of or dealt with in any manner by them. That is the second option.
That would, my lord, in fact, may not prejudice the bank more than me.
Yes.
In that case,
Yes.
the immovable assets cannot be sold because
So they cannot do anything on that.
on that.
Or otherwise, they have to pay for bailment of that.
Yes.
Or keeping it, storing it also.
Yes.
That is one other aspect.
Yes.
And was at any stage it was directed by the district magistrate that it was be handed over to the bank. It was not.
You may not by page 51. The first paragraph.
Oh yes, articles. Right. No, deliver its possession to the authorized officer of the petitioner.
Petitioner
Petitioner means the
bank.
bank, man.
Your authorized officer handing over authorized officer is working in a particular capacity.
No,
Can you deal
authorized,
with the property?
no, authorized,
Even if the authorized officer has that.
no, authorized,
Authorized officer is not the bank.
no, authorized officer is an officer appointed under the SABYASACHI Act by the bank.
True. Maybe. But what is the role of the authorized officer?
To carry out the functions under the SABYASACHI Act.
Obviously.
Provided that is invoked for the movables.
Very well. So you mean to say, Mr. Nag, that this authorized officer possession is a bank's possession, basically?
Yes, yes.
Very well. Very well. Anything else, Mr. Das?
Therefore, my lord, on the point on which my learned friend urges, my lord, my respectful answer is, my lord, 14.2 takes care. And 14, as your lordships know, my lord, is a, what should I say, my lord, is a sequence of the statutory provision to give effect to 13.2 and 13.4.
Yes. Yes.
Now, any order which is passed under 14, beyond 13.2 and 13.4, the measures taken under 13.2, 13.4, my lord, my very respectful submission can be, my lord, whether we call it a rectification or whether we call it, my lord, within the scheme of the act, to restrict it to only the immovables.
Mr. Dotto, can you please tell me, in a civil case, suppose there was an execution proceeding, an immovable property was, by way of execution, that property was to be taken, the possession of that was to be taken. If there are movable properties lying there, what is the modality?
My lord,
And what will be done? The bailiff takes, initially an opportunity is given to.
my lord, two
give
things. First
Yes.
is, my lord, if the entire property was mortgaged, then, my lord, whatever is there, my lord, is taken, including any improvements made, my lord, in course
Not
of.
improvement in the property physically.
Yes,
But suppose there's a jewelry box in a house, the house was mortgaged.
yes.
Jewelry box was not
Not the subject
mortgaged.
matter of mortgage.
What happens to that? in
Therefore,
a
the
civil proceeding?
person who owns whatever movables, including jewelry box, he is entitled to that because that
it-
has not been hypothecated.
Suppose he does not take that back, then what happens? I'm not sure. I've forgotten actually,
My lord,
because I've lost touch with civil execution for a long time.
and your lordship knows I never had touch with it.
No. So very I'll have to look into that also.
Yes.
Because that also has to be considered
Yes,
in
yes,
perspective.
Now, here is a case where, my lord, there are, my lord, two forms of security. And, my lord, in the normal civil.
You are very clear. The entire schedule everywhere, it's the movable properties which are mortgaged. Admittedly, that was the property which was sought to be covered by the 13.2, 13.4.
Yes.
And that should have been the perspective of the section 14. Gone beyond that, subsequently rectified by this order, which is within the scope of 14.2 itself. That is your argument.
But one more point kindly consider, my lord.
Yes.
But under the ordinary law, my lord, whenever, my lord, any immovable property is to be taken over by the mortgagee, my lord, a decree of the court is required.
Here,
Yes. Now, my lord, here, my lord, the legislature has made a departure.
yes.
The departure is that you're not required to go to the court. You're being given extra powers. Now, this extra power is further strengthened by, again, a summary proceeding. I do not know whether at all it can be called a summary proceeding. I think an administrative proceeding in the garb of section 14.
Section 14 is an execution without order to return rule 101.
Right.
97 to 100.
Yes. So therefore, it is
Yes.
not a judicial proceeding, not even a summary proceeding. So it's
No.
an administrative one.
Basically.
Now, in this administrative proceeding also, when 14.
Not your fault, Mr. Nag. That is an administrative. Take it seriously.
There is a scope within that section itself, where the magistrate can do something to execute whatever is there under 14.1. Now, please consider, in this background, whether the Gujarat High Court was right in saying that it becomes functus officio.
Well,
But these are my submissions. But please consider, if this can be done, that if inventory is done, I'll be at least satisfied that my goods
inventory
are.
done and it be kept where? It will be returned to you, but an inventory will be done.
No. I'm not asking for return because
Only inventory.
yes, my hypothecation is still subsisting.
Right. That was what I was thinking actually.
Yes.
So whether this could be subjected to that,
Yes.
that is the precise reason whoever it is with, cannot part with the property. Even if
Right.
it goes to you,
Right.
I'll direct you not to part with it.
Yes.
Because
Well, I'm clear on my, Millard, instruction that I don't want it through this writ court. Wherever, if I have any right, I'll go and agitate over there.
very.
But I want that my properties be at least inventorized and secured, Millard, in whichever manner your lordship feels would suffice.
Very.
Millard, I had an apprehension that is recorded at page 130 in my application,
Apprehension
that it may be removed. So that, Millard, tomorrow I am left with nothing to prove that my property is being.
yes, they get an order on the hypothecation before getting a
Yes.
formal order under.
Yes,
So that is
yes,
what is your
Yes, yes.
Great.
Yes. But these are my submissions.
Thank you, sir.
Short.
Yes, Mr. Nayak. Short reply.
Short. Well, so far as the judgment of the Gujarat High Court is concerned, which has been relied by the same district magistrate on an earlier occasion, and on an application filed by the borrowers, same parties. That relying upon that judgment, that is a decision bench judgment, and relying upon that judgment, the same learned magistrate came to an opinion that I am functions official. So, and that judgment has not, that order of the district magistrate has not been challenged by the borrowers as yet. So the borrowers today can't say that Gujarat High Court was wrong. And
Bad argument. Bad argument, sir. No precedent. This is magistrate order is not a precedent on himself also.
no, that order has not, district magistrate
Your ultimate
relying
logic goes there, Mr. Nayak.
the district
He relied
magistrate,
on Gujarat High Court. That has not been challenged by them. Therefore, that is binding on. That is neither binding on the magistrate nor on them nor anybody.
I'm not,
Gujarat High Court in Gujarat, definitely that's a binding judge. But magistrate relying on it on a previous occasion does not give any occasion to you to argue that it is binding on the magistrate even.
no, I'm not saying on binding on the magistrate. I'm saying relying upon the same judgment
No estoppel on that.
on earlier occasion, the magistrate
May have.
functions official.
Yes.
But for the second time, the magistrate also accepts that.
May
But
deviate
on
now
a
also.
different ground,
That's immaterial, Mr. Nayak. That's immaterial. Magistrate relies on the same judgment again and again on whoever's insistence. That is not not a relevant ground. That is not German for the present adjudication.
Now, my lord, kindly sees
No,
Well,
Gujarat
I'm a
High Court,
senior
I am not
friend.
saying it does not have persuasive value. Definitely it has. That has to be considered. But I am not saying that. But it does not have any precedentiary value on the magistrate. I mean, the magistrate relying on that does not have any.
now, my lord, the second point which was argued, my lord, the section 14 subsection
Yes.
2. Section
Yes.
14 subsection 2.
It's carrying on still.
Yes. Now, section 14 subsection 2, section 14(1), what section 14(1) says? Section 14(1) says that where the secured creditor requires an assistance from the magistrate to
Yes.
take physical possession of the property, he can apply before the magistrate. Now, the other the entire section says, the proviso and the entire section
Mr.
says,
Nayak, it says it for the purpose of taking possession or control of any such secured asset,
right, secured assets.
which the movables were not.
Movable,
That is a cardinal question here.
my lord, the movable assets is also a secured asset. It may be a case that it was not invoked. Section 13(2) in this,
Not a secured asset under the
The secure-
13 to 13(4) proceeding.
no.
That is what is to be considered. This secured asset, this term secured asset, because the definition also secured interest to security interest.
Yes, hypothecation is a secured interest. This is
That's a
security.
different cause of action, Mr.
Yes,
Nayak.
yes.
That has no bearing on this 13(2) or 13(4) proceeding.
No, because in
So
13
this
to
14, the construction of secured asset in the section 13(2)(4) proceeding and the corollary 14, no,
has to be restricted to 13 to demand notice.
Yes,
Has to be restricted to
then it
13
has
to
to be
demand.
the movable property, immovable property only.
Because it is only mentioned in
Yes.
the
So the magistrate, why not the magistrate acted dehors his powers in directing the movable properties to be taken by the
right.
authorities?
If that be the case,
Yes.
the appropriate authority to decide that issue is the tribunal under section 17. And and the borrowers have applied.
What about section 14(3)? Why not only the writ court can interfere?
No, section 14.
What? No. Read section 14.
I have seen.
You have to read out, Mr.
No act of the Chief Metropolitan Magistrate of the District Magistrate, any officer authorized by the Chief Metropolitan Magistrate or District Magistrate done in pursuance of this section shall be called in question in any court or before any authority. Now, this any court or authority, there is a depart so far as
Does not cover tribunals.
not section 17. Why? Because whatever district magistrate has done under section for handing over possession of the secured assets, which is an action taken under 13(4). So whatever
And
action,
the language of 17 is very wide.
very wide, and even it has been
Measures to recover security.
yes, and it has been interpreted by the Honorable Supreme Court of
Yes,
I
yes.
think in Nobel Kumar only, that because there is not express
Right.
provision in section 17 that an order passed under section 14 can be challenged under section 17. But it can be because it is a part of an action taken under sections 13 subsection 4. Now, so far as section 14 subsection 2 is concerned, this is what has been done in page 51. If Losses may kindly see is page
51
51.
includes movable properties.
No. Page 51 of the repetition, my lord,
Yes.
where it says that
It includes movable properties.
not only that,
Yes.
what assistance of the police authorities,
Yes,
as
everything.
everything, like, to execute an order passed under section 14 subsection 1.
Yes.
If magistrate requests, whatever assistance magistrate requests, he can opt out those assistance, which is provided under section 2.
Mr. Anna, can you tell me how long after this order they preferred that application?
Which application?
The application on which the impugned order has been passed?
After this,
After page 51? How long after page 51 order?
51 is January, 6 January
I filed-
2023. And if this application was filed in
14th June.
14 June.
Page 125.
And challenge, and the other point which was not answered, this entire order which is at page 51, the entire order is a subject matter of challenge at the instance of the private respondents before the DRT presently also, because this order passed under section 14 on 6 January 2023 has been challenged on 3rd of March, much before filing this application before the magistrate. It was always open for the whatever mistake the magistrate has done. If magistrate has done a mistake, whatever mistake the magistrate has done in the passing in
Mr. Nag, do you say they ought to have had a liberty to approach the tribunal
yes,
in connection with that main proceeding against section 14
yes,
with this prayer?
yes. That was my argument
That can
also.
also be an order passed by this court. We can give them the liberty to do that now.
Yes, because that was my argument also, because
Yes, that is your argument. What?
before the magistrate, that this learned court does not have the jurisdiction to consider this application. If this application has to be considered, it has to be considered by the learned DRT.
Yes.
And that is all that right is always there, and the application is already pending. The main application challenging the main order is pending before the learned DRT. And another aspect, my lord, so far as the new inventory, for new inventory is concerned,
Yes.
that is not a subject matter of application. That was not the prayer made in that application in which the impugned order has been passed.
Not in the writ petition.
No, the writ petition is at my instance.
Oh, yes. I'm sorry. Yes.
And that,
Right.
that was not there.
Right.
Now, secondly, there cannot be a new inventory because the inventory was done in the presence of the authorized officer appointed by the magistrate.
Mr. Nag, can you bypass a fresh proceeding or a different proceeding under the law for obtaining those, for getting possession of those movable properties on the ground of hypothecation by way of this section 14 order? I mean, you ought to have filed a separate proceeding for that, for getting possession of those mortgage, the hypothecated goods.
I should have. But rightly, wrongly, the magistrate has given me that.
That is the question, rightly or wrongly.
Right.
Here
And
only, that is the only question. Here.
that is the only question, and that
If wrongly, it has to be set aside. If rightly, yes, very well.
yes. Now, if you'll just kindly sees the inventory.
Why should I see the inventory?
No, inventory has all the details, like all the details of the immovable assets which were there at the.
How do I know unless I see personally?
Because it was been prepared by the seal bailiff.
Looking into the inventory, the Ritcourt will find out that everything has been mentioned there.
No, I'm not saying so. I'm saying that whatever was there, because it has been witnessed by the borrowers, they have signed the inventory.
Neither of us know whatever was. They have signed definitely.
Because it was done in their presence. It was signed by the seal bailiff.
That's true. Yes.
And these were prepared under the securitization rules.
This is on the fresh inventory. This is your argument on the fresh inventory prayer.
Yes. And this has been done under the rules, because the inventory which was prepared, rule 4.2.
Fresh inventory is probably, may not be granted. Well, this is all.
The prayer that I made before the magistrate, that this application should have been preferred before the DRT, that has been recorded also in the man.
No, that can be an argument on law also. I'll reserve my judgment on this.
Well, there is no reply to reply, but one thing. Number one is, the sale notice has been issued.
If it is one thing, we said that there cannot be any number one.
Yes. Sale notice issued already, sale fixed on 8th of August with as is wherever, whatever there is.
Yes, I get Mr. Bordon's point. It will be before that.
So that is only the immovable properties.
So that's
No.
That's it.
How do you say that?
Because it is there.
As is where is.
Schedule is there.
What?
In the sale notice, the schedule of the property to be
What
sold
do you
is
do
there.
with the movable property? You will be more of a geoparty.
Whatever there is.
You will have to keep
But
custody of that.
It has to be in my custody, because I have to
Shall not
preserve that.
Very well,
The law says that it is my duty to preserve that.
It key. Sale notice, it recorded.
Whatever there is, your Lakshmi kindly have a
As
look
is
at
where is in the sale notice.
Yes.
The immovable property mentioned.
Hearing is concluded, judgment reserved.
I'm grateful. Oh, sorry.
Item 8.
Yes, Mr. Sarkar.
I appear for the petitioner, my lord. Mr. Banerjee was to conclude.
Yes, right. Mr. Banerjee, yes, your matters.
But I thank him, my lord. He has a genuine personal difficulty, but he still made time to come and do
Mr.
this.
Banerjee is on a different plane.
Great.
Does not mean that his matter is also on a different plane. Yes, Mr. Banerjee.
My lord, I'll just show Milord the previous order passed by my lord Justice Bhattacharya in the Milord previous round of litigation first. My lord, I'll show Milord what the exact directions were. And then Milord, I'll show how Milord have complied with those directions and why Milord this writ petition is no more Milord maintainable. My lord will kindly have a look at Milord the order passed by my lord Justice Bhattacharya at page 214 in the second volume.
Yes.
Milord, the ordering portion is at page 227.
Right.
There were twofold directions. First, kindly take paragraph 24. WPA number such and such is accordingly allowed by a declaration that the impugned notice dated 27th April, Milord, which is at page 109, 13-2 notice, previous 13-2 notice, is liable to be quashed, restraining the respondents from proceeding in accordance with the said impugned notice, as also the later dated 30th November 2021. The respondent number 1 bank is directed, my lord, kindly Milord take note of these directions, directed to consider the restructuring of 3 loans of the petitioner number 1 afresh in terms of the resolution framework 2.0, subject to the petitioner number 1 fulfilling all the conditions contained therein. So, Milord, I have to, Milord, consider his eligibility, Milord, for having his 3 loans restructured only, subject to, Milord, fulfillment of all the conditions as per the resolution plan. The eligibility of the petitioner shall be considered strictly in accordance with the resolution plan. The respondent number 1 resolution framework the respondent number 1 bank shall also consider whether the petitioners are entitled to this emergency credit line guarantee scheme loan in view of the changed circumstances which have been placed before the court. The respondent number 1, then my lord, a time is my lord fixed. Now, before I take your lordship, my lord, to the compliance part, my lord, may I show, my lord, the notice dated 30th November 2021, which was, my lord, set aside. My lord, that is at page 105, my lord, in the first volume. My lord, my learned friend has interpreted it, my lord, to mean that, my lord, the classification of the loan accounts as NPA was also set aside, which in my humble understanding was not done. My lord, the notice said, with reference to the under-mentioned credit facilities by the bank, you have not.
No, Mr. Banerjee, probably he did not mean that exactly because that was not
That
set
is his
aside. That
averment.
happened previously.
That is
Maybe his averment, but that
Right.
is not the
So, my
effect.
lord,
It's a
NPA
short-term.
remains.
He argues that the NPA remained in that sense. NPA was not set aside, but the nature of this injunction, the restraint order, that is of a permanent.
I cannot treat him as an NPA, but NPA remains
You
otherwise.
have to again mark him as an NPA.
No, that cannot be done under the prudential norms. That cannot be done under the prudential norms because my lord, prudential norms have set out, my lord, certain, my lord, conditions under which, my lord, an account can be classified as NPA when it, my lord, is no more a standard asset.
Mr. Banerjee, if it becomes NPA once, it cannot be revived.
My lord, it can be regularized.
It can be regularized. If it is regularized, it can
Well,
be
it has to be
marked as
regularized.
NPA again subsequently for a subsequent failure.
Can be done. But, my lord, has to be regularized, my lord, adhering to the, my lord, prudential norms only. And, my lord, here, my lord, when my learned friend is also not suggesting that NPA, my lord, had gone, my lord, I am not, my lord, then troubling your lordship with that.
No, don't put it in his
remained-
mouth. He's suggesting something else. He's suggesting that in a different phraseology. He's suggesting that there is an order restraining you from giving effect to the notice
This
which relied
notice.
on this letter which relied on that NPA. If there is a permanent restraint on you to give effect to this letter in the garb of another letter, you just cannot give another letter and obliterate the effect of the order.
Without first considering his eligibility. Right. Now, my lord, kindly see, my lord, the resolution framework. My lord, I'll show.
You are right. This order, this
NPA
letter
is in suspended animation till I take a decision.
at best. Yes, yes.
Till I take a decision. That is the
True.
worst possible case for
Worst
me.
possible case against you. Right.
Now, my lord, kindly take the resolution framework. My lord, page 101 is the first, my lord, notification by Reserve Bank. And my lord will kindly, my lord, keep in mind that, my lord, the direction was to consider his eligibility for restructuring, my lord, the 3 loan accounts. Nothing else. Now, my lord, this, my lord, notification has 2 parts. One is, my lord, restructuring of credit facilities, and one is, my lord, enhancement of, my lord, working capital limit. It has 2 parts. My lord, the direction was to consider the restructuring, my lord, his eligibility to have the 3 loans restructured. Now, kindly take, my lord, page 101. My lord, clause 2. My lord, may I place, my lord, clause 1 first? Please refer to circular number such and such dated 6th August 2020 on restructuring of advances to MSME borrowers in view of uncertainties created by the resurgence of COVID-19 pandemic in India in the recent weeks. It has been decided to extend, kindly mark, the language in which, clause 2 is couched, because I will show, the difference, in the language used in the other clause where, it deals with, enhancement of credit limit in working capital. Clause 4. But the language is different. Here it says, it has been decided to extend. So it's a duty to extend. It has been decided to extend the above facility for restructuring the existing loans without a downgrade in the etc., subject to the following conditions.
But there it is permitted to review.
Yes.
So that's an option.
Discretion. And that is the way, the rate petitioner has understood it in his own averment. I'll show the averments. Now, kindly take clause V, Roman 5. Subject to the following conditions.
So you are trying to distinguish between restructuring and enhancement of
he
capital.
himself has distinguished it, in his rate petition. And he has never paid for, any benefit under clause 4. I'll show that also.
Mr. Banerjee, please distinguish for me the concepts. I mean, can enhancement of capital sanction limit not be a component of restructuring?
No, can't be.
Explain that concept to me also in commercial terms also.
Yes, Milord. Before that,
Very
Milord,
aware
show
of that.
Milord, subject to Milord, my limitation of understanding, Milord, I will definitely try.
You have a
Milord,
limitation
explain.
of understanding. I have no understanding. That's why please explain to me.
Kindly do not
On this
embarrass.
point, no, I have no understanding.
Kindly do not embarrass. Milord, may I just show the eligibility?
I'll stimulate myself before this. Come back in 10 minutes.
Great.
Yes, please.
My lord, I have shown your lordship, my lord, the exact directions. And now, my lord, I was showing your lordship, my lord, the circular, my lord, the resolution framework, my lord, at page 101. Which has, my lord, two parts in it. One is restructuring and one is, my lord, enhancement of, my lord, the credit limit in working capital. My lord, the difference between these two is, my lord, restructuring, my lord, encompasses everything. My lord, by way of restructuring, my lord, a term loan may be, my lord, converted into a cash credit facility or any other kind of facility, and, my lord, vice versa. And, my lord, the mode of repayment may also be altered. My lord, separate, my lord, credit facilities may be, my lord, granted. My lord, that is what is restructuring known, my lord, in banking parlance.
Working capital may very well be a component of it at best.
At best. And my lord, here clause 4, my lord, in the second page says, my lord, enhancement only of the credit limit, keeping, my lord, other terms of the credit facilities unaltered, like, my lord, the quantum of, my lord, EMIs. My lord, suppose, my lord, if I, my lord, just, my lord, try to take an instance, my lord, suppose, my lord, he was enjoying a working capital term loan of 50 lakh. My lord, I can enhance it to 70 lakh. But, my lord, at the same time, my lord, the EMIs, my lord, are kept unaltered. My lord, very restricted meaning, my lord, so far as this enhancement is concerned.
Right.
Now, kindly, my lord, have a look at the eligibility conditions, my lord, prescribed in page 101 for restructuring. Roman 5 says,
Not restructured.
earlier. And, my lord, it's admitted position of fact, he has availed, my lord, one restructuring facility. My lord, there is no dispute with regard to that. Now, kindly come to, my lord, clause 4 at page 102. In respect of accounts of borrowers which were restructured, firstly, my lord, this was not, my lord, within the directions, my lord, passed by my lord Justice Bhattacharya to consider his eligibility under clause 4. He did not even apply for
directed
this.
restructuring.
And he said LGS.
Subject to, yes, subject to compliance of
Strict compliance of,
strict
my lord.
compliance includes 5, Roman 5, which says previously, if not obtained, they obtained, so they are not eligible.
Absolutely.
One, and about the ECGS, that the other aspect of the
ECLGS, which, my lord, my
ECLGS.
learned friend submitted, he is not pressing on that, but
Pressing right now,
still,
yes.
still, my lord, I will respond to that. My lord, clause 4, kindly have a look at page 102. In respect of accounts of borrowers which were restructured in terms of MSME restructuring circulars, lending institutions are permitted as a one-time measure. If they choose, they can do it. He is asking
This
for,
happens after restructuring also.
may happen
As per clause 4.
yes, yes, absolutely. Can happen after
It's a
restructuring
different stage.
at a different stage. And, my lord, this is absolutely left to the discretion of the bank. He is
Yes.
asking for a mandamus. He must show that, my lord, I had a legally enforceable, my lord, duty, my lord, to do this.
Right.
Lending institutions are permitted as a one-time measure to revive the working capital sanction limit and a drawing power. Then, my lord, there is a qualification based on the assessment of the working capital cycle. You know, looking at his past performance, working capital cycle. My lord, bank may or may not take a decision, my lord, to give him a benefit. Now, my lord, how, my lord, he has construed this, kindly, my lord, just take, my lord, note of 2-3 paragraphs of the writ petition. Kindly, my lord, have a look at I'm sorry, my lord, I'm just taking your lordship's time. My lord, page 3, paragraph 4 and page 5, paragraph 7. My lord, these are his averments. He knows this is discretion of bank. Now, my lord, after the judgment delivered by my lord Justice Bhattacharya, my lord, he made, my lord, a proposal, a request. My lord, that request is at page 228. Kindly see, my lord, what he is asking for. And he owes, my lord, almost 8 crores of rupees to me and says this is not an adversarial litigation, my lord, putting a spanner in the SABYASACHI action. More than 8, almost 8 crore, my lord, is payable. My lord, kindly take page 228.
They never asked for an enhancement of the
Never ever. Kindly, my lord, have a look at his own, my lord, representation immediately after, my lord, Justice Bhattacharya's judgment. He's asking for something here which was never asked for. And there is a timeline, my lord, under the resolution framework, my lord, to ask for something. Kindly, my lord, see, kindly take paragraph 4, my lord. This is a communication from him, my lord, on 7th of February 2023, after, my lord, Justice Bhattacharya's order, my lord, on 19th of January 2023. My lord, I'm not troubling, my lord, with all the paragraphs. Kindly take paragraph 4. Before that, he says he is a good Samaritan, he does not have any adversarial litigation, my lord, against us and all that. Then, my lord, 4. Therefore, I pray to you with all my humility that my proposals given at page 135 and 136 of the writ petition, the previous writ petition, annexure P24 be considered and allowed, since that will fully benefit the bank and also preserve my family, business and livelihood. I assure you that there will be no further default on our part if any one of the two plans at pages 135 and 136 are allowed. In this regard, a copy of those two plans appearing at pages 135, 136 are attached here too. I reiterate that allowing either of the two plans will help the bank recover its money. My lord, is thinking about me also, which I have always intended to pay back. My lord, for last few years, my lord, nothing is forthcoming, as noted in the judgment and order dated 19 January 2023. Now, my lord, kindly have a look at, my lord, his proposals, pages 135 and 136 in the previous writ petition, which, my lord, he has not annexed here.
The page 237 to 38 has different things.
Different things. Kindly see, my lord, these are the pages. This is, my lord, the service copy. Sufficient.
Pages are 135
5 and 136.
That sale proposal.
Yes. Now, my lord, this proposal cannot be, my lord, acceded to. Firstly, this is not, my lord, covered by.
So, Banerjee, can you arrange for these copies to be just copies?
Yes,
of
yes.
Any
My
one
lord.
of the pages would do because they are the same.
My lord, may I, my lord, hand over the entire writ petition?
Please don't.
My lord, we
Very.
can do that. Since we are the petitioner, we can do that. I'm carrying the writ petition with me, Lordship. We'll take those
You
pages.
can do
we'll
what?
We'll submit those pages separately right now because I'll also rely
Any
on
one of the pages will do, Mr.
Lordship,
Shortcut,
I'll
because
do
those
that.
are exactly identical.
We'll
When identical means exactly.
Now, my lord, he wants, my lord, the property at Delhi to be sold by him.
Which is said also, Mr. Shortcut. said
Correct.
also.
Kindly have a look at, my lord, section 13, subsection 13.
It's obvious.
And my lord was, I'm sorry.
Yes, yes.
My lord, yesterday, my lord was inquiring whether DRT has the power, my lord, to say that, my lord, a classification of a loan account as
Yes,
NPA is bad.
yes.
My lord, DRT can do that. My lord, my lord, could lay my hand on a Delhi High Court decision.
Whatever, yes.
My lord, relies upon all, my lord, Supreme Court decisions starting from Nobel Kumar and say, my lord, that DRT can do everything. It's not confined to chapter 3 only, can take care of chapter 2 also.
Are you collecting Delhi High Court judgments now? Yes. In commercial matters, Delhi and Bombay are the courts which are reigning now, quote unquote. Yeah. So you very well can cite those. Yes. Any particular paragraph, Mr.
Yeah, the inter judgment is on that. Inter judgment is on that.
No, regarding this NPA declaration.
No, it says, my lord, chapter 2 and chapter 3. My lord,
Right.
says a broader view, takes a broader view of the matter. My lord, the question that was posed to the Honorable Court was whether, my lord, this exercise of power under section 17 is restricted to chapter 3 only,
All right.
13.4 only. My lord, relying upon Nobel Kumar and all the decisions that followed Nobel Kumar, my lord, it says that, my lord, chapter 1, chapter 2, chapter 3, everything comes under the, my lord, jurisdiction of section 17. And, my lord, Nobel Kumar reminds me, my lord, the comment that fell from your lordship.
Yes.
My lord, the creator is known by his creation. So, my lord, I say,
Miscreation, mate. Or miscreation, if he's a miscreant. We don't know the first name. Maybe castigated by the court also. Yes. Yes, sir.
yes.
So this is
my
all.
lord,
Yes.
yes, my lord, these are, my lord, So firstly, he has not applied for something, my lord, which he is now asking for. My lord, he wanted to sell his property, which he is statutorily, my lord, prevented from doing. And my lord, restructuring was the only thing that was directed, my lord, by the my lord honorable court. And my lord, one more thing, my lord, on this clause 4. My lord, where my lord enhancement of my lord credit limit. My lord has seen my lord the qualification while my lord enhancing the credit limit. My lord, at the bank's discretion, bank my lord must look into my lord the past affairs. My lord, I just show my lord page 237 once.
Their past is very tense. Yes.
My lord, these two tables. My lord, at page 238 shows my lord his past affairs.
Obviously.
And a borrower, my lord, who is not paying me, who owes my lord 8 crore and odd, after my lord getting a restructuring, my lord wants my lord further loan from the bank, and my lord wants a mandamus for that. These are my lord my most examples.
Yes, Mr. Sharma.
Lots of prejudicial submissions, but all answerable on facts based on undisputed records. Well, at first, the judgment cited by my learned friend, 2023 SEC Online, Supreme Court, page 435. Where, my lord, the submission was that the Supreme Court has castigated the action of Honorable High Courts. Deprecated. No, the word castigated was used. I saw on YouTube yesterday. It says,
I'll have to be very cautious, Mr. Sharma.
It says that was the submission was that castigated for interfering with 13(2) notices. This judgment does not deal with that at all. This
castigation ta bolechi I received castigation bhebe dekh YouTube
what doesn't matter. My lord, this judgment does not consider section 13(2) situation at all. This judgment was pursuant to a writ petition being admitted after 13(4). Under section 17, one can approach the DRT after 13(4), that is recognized in the Supreme Court decision. Therefore, the Delhi High Court does not hold water at all. It's ex facie contrary to all these authorities of the Honorable Supreme Court. This judgment, Lordship, does not state anything new. It is a mere reiteration of previous judgments such as Phoenix ARC, Federal Bank, Satyavati Tondon, etc.
So in your case, it's pre-13(4).
I have challenged. In fact,
obviously,
I have challenged for obvious reasons, and that has nothing to do with the facts of this case. I'll show, my lord. This was a simplicitous surfacey action. Loan taken, not repaid, 13(2), 13(4), writ petition, therefore not maintainable. Our case is not a simplicitous surfacey action that has been held by my Lord Justice Bhattacharya in the previous writ petition, because in our case there is a loan. Then there is COVID, which is an extraordinary situation treated as force majeure by the government of India. And there is the intervention of a statutory circular, casting a statutory obligation on banks to exercise discretion in a particular way. The exercise of discretion has to be in terms of a statutory circular. There is an intervention of statute. Therefore, I say that the duty cast by that circular has not been followed in accordance with the circular. Therefore, everything flowing from that bad decision automatically falls to the ground. Therefore, if the decision to reject my RF2 is bad, everything that follows, declaration of NPA, the 13(2) notice, will automatically be bad, and that has been accepted by the Honorable Court in the first instance. Therefore, Lordship, this judgment does not apply. Next, my lord, this merely reiterates Phoenix ARC, Federal Bank, Satyavati Tondon. All these judgments have been dealt with by my Lord Justice Bhattacharya in paragraph 6 of the judgment as to why those were cases of simplicitous surfacey action, ours is not. in any event, paragraph 18 of this judgment makes it very clear that in extraordinary circumstances, the writ is maintainable when there is intervention of statute, which is our case, which was accepted on the last occasion. Because COVID was an extraordinary situation. In fact, because of that extraordinary situation, this RBI circulars came. Otherwise, it would not have come. Therefore, Lordship, in my humble submission, the judgment does not apply. In respect to clinch the matter, I will place two paragraphs of Honorable Justice Bhattacharya's judgment. Paragraphs 6 and 8. Paragraph 6 is at page 217, volume 2.
Yes.
Well, at first I'll read paragraph 5. Issue raised on behalf that the petitioner should be before DRT is answered against the respondent in favor of the petitioners. Well, the same argument made right now was made there. That what was sought is not in terms of circular, that this should go before DRT, not maintainable, etc. Well, at first, Section 17(1) of the SABYASACHI Act entitles any person, including a borrower, to make an application before the DRT having jurisdiction in the matter with a certain time frame against any of the measures taken by secured creditor under Section 13(4) of the Act. Section 13(4) authorizes secured creditor to take any one of the more measures, etc. In the present case, my lord, it goes on to say, the notice dated 27(4) was issued under 13(2) of the Act, which would be evident from the impugned notice itself. Hence, the stage for approaching the DRT, which is the statutory alternative remedy under SABYASACHI Act, had not arrived as on the date of the impugned notice. Phoenix Arc referred to, Satyavati Tondon referred to, both cited by the bank, involved notices under 13(4) of the Act, and hence are distinguishable from the facts of the present case. Thereafter, the prayers are noted. Why my prayers are not bad in paragraph 7. And thereafter, my lord, I'll place paragraph 8 with my lord's permission, page 218.
Yes.
The cause of action pleaded in the writ petition persuades this court to hold that the writ petition is not a SABYASACHI action simpliciter and is premised on the statutory duty cast upon the respondent bank to enforce the RBI circular, which was to be enforced in accordance with its object and intendment, and the respondent bank was to exercise its discretion in the matter of restructuring the petitioner's loan as an MSME. The writ petition brings to the fore the failure of the respondent bank to exercise its discretion in account. I have never said that there is no discretion. In fact, that is the case with any statutory authority. There will be a discretion in all such cases. What lordship we are concerned here with is exercise of discretion. That is what we are concerned with. In accordance with the circular on acceptable and transparent standards, the decisions relied on by the bank, namely such and further decisions were cited, do not apply to the facts, since all these decisions dealt with 13(2) notices without any duty on the part of respondents to enforce an RBI circular. Rather, my lord, it was held that Federal Bank supports my case, because Federal Bank said it's not maintainable when there is no question of a statutory duty. But where there is, then writ petition is maintainable even against a private bank, my lord. So this clinches the issue in my humble submission, my lord, and this issue has already been settled. The submissions of Mr. Banerjee, my lord, essentially is challenging the decision of the learned single judge, my lord, without really challenging that decision in appeal. That is the effect of the arguments, my lord. Next, it has been argued that there was no assailing of the NPA declaration. It was a mere communication, the 30th November 2021. My lord, I have accepted that that per se did not create that declaration of NPA. But what I argued was, unless it is communicated to me, the fact is that I am aggrieved by that NPA declaration once I get communication of it first. Next is, my lord, NPA declaration by itself means nothing unless it creates certain situations which the bank can exploit to take certain measures against me. For instance, my lord, once an NPA, an account is declared as NPA, certain consequences follow. Without the bank being able to act in terms of those consequences, the NPA declaration has no effect, no value. What was done in this case is the fact that I've been declared an NPA and that consequences could follow as a result of the declaration, that was set aside. it essentially means that the NPA declaration became stillborn in that sense, because the judgment related back to a situation which is July 2021, predating the declaration of NPA in November 2021. Therefore, by legal fiction, so to speak, by operation of the judgment, we were taken back to a situation in July when there was no NPA declaration. Therefore, the question of the NPA declaration surviving as on date doesn't arise. Next, Lordship, is that this was in the submission is that this was only in suspended animation and that it would get revived once they would take a decision. Same case, Lordship, in case of the first round of litigation, my cause of action pertains to the rejection on 10th of April, which is prior to the issuance of the 13-2 notice. Therefore, in my argument, in my submission, if I'm correct in saying that the rejection under RF 2.0 is bad, then of the obvious consequences that the NPA declaration or the 13-2 notice, none of them can be given effect to.
In the writ petition, did you ask for a setting aside of the NPA declaration itself?
Lordship, may I
please check?
Ballot was
in the
I have
previous
the writ petition, Lordship. I'll
just check up the prayers whether you sought
Lordship.
for a
Lordship.
the 29th of November
Lordship.
declaration.
Lordship. No, that is the documents.
Apparently, no, because that was never granted.
We sought Lordship declaration and then mandamus, recall, and rescind letter of 30th November 2021.
So that was granted by the court.
That was granted by the court, Lordship.
Now, Mr. Sarkar, you may be justified in saying that the discussions in Justice Bhattacharya's judgment practically show that for all practical purposes, Justice Bhattacharya was of the opinion that, clearly of the opinion, expressed opinion that the NPA declaration prior to restructuring being considered
Lordship.
was bad, or at least deprecated.
Lordship.
But the ultimate order which was passed says that the order sets aside something which is immediately subsequent to the declaration.
Lordship, giving effect to that declaration.
Giving effect to that declaration, yes, yes. 29th, the declaration was there, NPA declaration. 30th, that letter was issued, that was set aside by Justice Bhattacharya.
And then that is acted upon.
But in the that is acted upon. But in the discussions, it appears as if the setting aside should go back to prior to the declaration of NPA.
Lordship.
Because the NPA declaration itself was castigated by Justice Bhattacharya.
Lordship. That is.
But the ultimate effect is there can be two arguments on this. This could have had two conclusions. Justice Bhattacharya.
My lord.
One is that yes, the restructuring should have been considered first. Since that was not done, the NPA declaration goes, and that is also set aside, which was not done. That could be one of the conclusions. The other conclusion could be, as it appears from here, that yes, the restructuring should have been considered even prior to the declaration of NPA. But for the time being, the NPA declaration is being kept in suspended animation. The restructuring ought to have been considered first. Now, if your restructuring succeeds, they have been directed to consider that restructuring prayer first. Now, if that restructuring is considered and allowed, then there could not be any other effect from automatically rendering the NPA declaration void or bad. That had to go. If they permitted restructuring, as per Justice Bhattacharya's direction, the only effect could have been that the NPA declaration goes. Because it cannot be that the NPA remains at the same time and the restructuring goes there. Now, you may argue that by virtue of Justice Bhattacharya's order, the NPA declaration goes.
Lordship, that is my argument.
You may argue that because unless that NPA declaration goes, there cannot be any consideration for restructuring even as per the circular. Because unless
in my case that is the case,
eligibility does not come.
Yes, because that is prior to
your eligibility does not come in for the restructuring to be considered.
Lordship.
Now, since you have Justice Bhattacharya has directed restructuring to be considered, it may be construed that the eligibility that Justice Bhattacharya made you eligible to apply for that restructuring, the only effect of which is that the NPA declaration has to go by necessary implication.
My lord.
So otherwise it would be meaningless exercise.
Absolutely.
Because the first line they would have done would be that no, this has been declared as an NPA prior to this, which has not
Lordship.
been set aside.
Lordship,
Therefore, the restructuring goes on that count
Lordship.
itself.
Lordship. My only humble submission
I'll
is,
give you, yes.
my only humble submission is, all these arguments made, is it there in the
But we have to
rejection?
go by the ordering portion, Mr.
Lordship, all-
Shotkar. That is the
the only-
difficulty.
but-
NPA was never set aside by just.
Well, to my understanding is the NPA had to be stillborn because the NPA declaration which followed the rejection under RF2 in that fact situation was set aside. That can't be-
Stillborn would be giving a full stop to it, but it should have been in a comma or a comma, whatever it is.
But I would argue, Lordship, that NPA declaration would have to be revived. In any case, Lordship, even if my Lord is not with me on this point, and I assume that the position is that the NPA declaration could get revived, it makes, really speaking, no difference to my main argument, which
Yes,
is
yes, that remains.
my rejection is bad, therefore everything which follows the rejection is also bad.
That definitely remains.
At
That's a
this
separate
stage.
argument.
Yes, Lordship. So therefore, I will leave it at that. I will leave it to my Lord to consider that aspect. Lordship, my Lord, my learned colleague points out paragraph 18 of the judgment.
Yes.
May I just place it? The fact that the petitioner number 1 was eligible for restructuring both under RF1 and RF2 would appear from such and such of RF2. And further, that the petitioner number 1's accounts were standard assets as on such and such. It is significant that the loan accounts of the first petitioner were declared NPA only on 29/11/2021. Second, the bank's failure to consider the petitioner's application contradictory to the purpose for which RF2 was structured and conceptualized by RBI.
Yes,
Namely,
definitely.
now, my Lord, I'm placing this to answer the next point as well, which is restructuring versus one-time measures. What essentially is argued that two are completely different. I never sought for one-time measure, which is absolutely incorrect on the face of it, because that's the documents are recorded in the judgment, as also the finding of the court, Lordship. Kindly consider the next sentence now. Second, the respondent bank's failure to consider the petitioner's application is contradictory to the purpose for which RF2 was structured and conceptualized by RBI, namely for a one-time measure of restructuring. My Lord, what this one-time measure is, it is really subsumed by restructuring because it considers aspects of the restructuring. The only condition given in the circular is that this will not be treated as a restructuring. The nomenclature restructuring will not be issued, will not be used, but this is in the nature of a restructuring. This is also, Lordship, noted in paragraph 12 of the same judgment. Page 221, para 12. RF 2.0 permitted banks, including respondent number bank, to grant further restructuring as a one-time measure to already restructured loans. This would be evident from clauses 2 and 4. Therefore, that was argued, placed, interpreted by by the learned court. My Lord, what happened was good, bad, indifferent. My Lord Justice Bhattacharya gave an interpretation by reading together clauses 2 and 4 of the resolution framework and permitted this measure, because only going by 2, since my loan had already been restructured, there could be no situation at all that I would get a review of the restructuring already done. That would only come across based on a harmonious reading of clauses 2 and 4.
Would an enhancement of the capital loan amount, would that help you?
My Lord, in my case, perhaps it would.
Only that?
My Lord, it is not just enhancement. That also, my Lord, also clause 4 does not talk about only enhancement. It talks about in respect of accounts of borrowers which were restructured in terms of MSME restructuring circulars, lending institutions are permitted as a one-time measure to review the working capital sanction limits and or drawing power based on a reassessment, not assessment, on a reassessment of the working capital cycle, reduction of margin, etc. It's not exhaustive, without the same being treated as restructuring. My Lord, this is only a case of what they will review. What decisions they can take is left to them. Has to be, Lordship, because the entire purpose, Lordship imagines a situation where a restructuring is given immediately prior to COVID. The assumption is in my case, it was given January 2020, based on an assumption that a normal situation will prevail and I will repay my loans as per the normal situation.
And there is scope of interpretation for this phrase also, without the same being treated as restructuring.
Lordship, that is
So it's
precisely
not-
the point.
Not instead of restructuring. It's without being treated as
It is
restructuring.
not as if an exception is carved out and it's limited to
May
that.
indicate that it is a restructuring for all practical
Absolutely,
purposes
but without
terming it.
treating it as a restructuring. By legal fiction, a further review can be done, further relaxations may be made, but in law, you will not treat it as restructuring, because that is the only purpose for this circular. If that is to be interpreted in the manner as sought to be argued, then this circular would have no meaning. Especially, Lordship will consider the facts of our case. I am given a restructuring in January 2020, March 2020, COVID comes, which alters everything. Admittedly, no one's disputing that. Therefore, Lordship, on that score as well.
Unless you were a mask company.
Lordship?
Unless you were a mask manufacturing company.
Lordship.
COVID changed everything for you also.
Perhaps my
COVID
clients
changed
would have
everything
been,
for them also. Yes.
perhaps my clients would have been better advised to have shifted their business.
Many people actually shifted. So many people.
Lordship.
So many big businesses.
Lordship.
Anyway.
My lord, the next point is therefore that question, that argument about the applicability of Supreme Court judgment, NPA declaration, as also what could be covered by this restructuring, my lord, I've answered.
So, Mr. Sharkar, please put in your written notes of arguments
Lordship,
because so
but
many
I-
whispers in the corridor.
My lord,
I'll have to be cautious that I don't miss out any of the points.
my lord, I will put it in a note,
Still,
Lordship.
it's on Justice Bhattacharya's judgment has to be seen thoroughly.
Lordship.
2 and 4 have to be seen thoroughly.
Lordship.
Definitely. These two have to be gone through.
Lordship, my only humble submission is it has to be given a positive interpretation, because this is essentially a social beneficial delegated legislation. In essence, has to be. Lordship will read RF 1 and RF 2 and see the reasons for the circular. It's to help these people. Now, my lord, the last is the most prejudicial part, which is my conduct. My conduct is so bad, I have not been paying for years. My lord, where is it demonstrated from the facts? The admitted fact is, the submission is, I was given restructuring once. I failed, I did not repay, there was severe default. Therefore, there was no question of giving me any further relaxation. That is the case. But what are the undisputed facts in this case, Lordship? That is not so. I got a restructuring in November 2019. The restructuring was effective from 1st January 2020. COVID came March 2020. But on my part, irrespective of the fall in my business during this period and immediately prior to the first restructuring, there is not a single case of default. Not a single case of default till August 2021, which is after I applied for the resolution framework. Lordship will see I applied for this measure, this relaxation on my restructuring terms, at a time when I was fully compliant with all obligations as per my restructuring plan, as also loan obligations, loan servicing obligations. Not a single instance of default. I did not approach the bank after I started making default. When I could foresee that a default is forthcoming, 1.5 years, 1 year, 8 months, my business is not being able to run. But even then, I'm clearing all my loan obligations. I am sticking to the terms of repayment. I assume that I will not be able to go on paying. So I approach them that, see, this is the situation. I am not in default yet, but a situation is going to come where I may be in default because of my position. Therefore, give me this relaxation. Therefore, Lordship, this entire argument that rejection of ECLGS loan, all the facts which are mentioned, my business is falling, etc., everything is extraneous to the facts of this case. They are not supported by the admitted facts of this case. In fact, it is just the opposite. All the prejudice that I have suffered thereafter in terms of default has been occasioned because of the non-restructuring of my loans. Had I been shown some degree of cooperation from the bank, this would not have happened. This would not have happened. For some reason, Lordship, the bank has proceeded with a prefixed mind in the matter. They, by whatever means, will ensure that my business is gone, because clearly recovery of the loan is not the only consideration. Because if they give me the restructuring, no prejudice can at all be caused to the bank, because if I'm given restructuring, there will be terms of restructuring. If I don't stick to the terms, the same actions can be taken. Nothing will become infructuous. It is not that something will go out of their control. Not their case. The security which is there, I have sought their permission to sell off that flat, to repay the loan with undertaking, including to court if necessary. So therefore, no prejudice. If restructuring is given, it will benefit me, but will not prejudice bank. If I fail the further restructuring plan, the bank is free to take all actions, the same ones which they have now taken, which have now assailed under the law. 13.2, 13.4, everything, Lordship. Therefore, I do not understand the prefixed mind approach undertaken by the bank in this matter, simply because no prejudice would be caused to them if they give me this relaxation, because if I fail, same acts can be taken by them. The last aspect, Lordship, is with respect to selling off the flat. Now, my lord, the amount of 8 crore was mentioned. This has shot up only after that period of August 2021 and thereafter. After this restructuring was by implication rejected and which was set aside. The amount has shot up only after that. It was originally 5.9 crore. That is the loan which I had taken. Based on the defaults which I had made in the installment, the amount would be far less. Even then, on the date on which all these acts were done, there was not a default of a single rupee. They were fully standard. It only came in November 2021. Therefore, that argument can't stick. With respect to the flat, if I was allowed to sell the flat, it would reduce significantly the burden of debt that I have. It would again, it would be to my benefit, reduction in my loan exposure. It would be to the benefit of the bank. A good chunk of their loan would get repaid. The argument has been made relying on section 13, subsection 13, that it can't be done. That is absolutely incorrect, because the 13.2 itself is being assailed. Because the rejection of RF2 is bad, everything that follows is bad. 13.2 is also bad. Even assuming that 13.2 is good, what does it say, Lordship? No borrower shall, after receipt of notice referred to subsection 2, transfer by way of sale. Oh, sorry, Lordship.
Yes, please continue.
No borrower shall, after receipt of notice referred to in subsection 2, transfer by way of sale, lease, or otherwise, other than in the ordinary course of business, any of his secured assets referred to in the notice without prior written consent of the secured creditor. My lord, that is all that I've sought. Written consent of the secured creditor, which has been refused time and again.
And prior to the, after Justice Bhattacharya's setting aside of that 13.2 notice, there was no 13.2 notice when they were directed to consider.
Lordship,
after Justice Bhattacharya's order, there was no section 13.2 notice any longer.
There was no
when
section.
They were considering, pursuant to Justice Bhattacharya's order, there was no section 13.2 notice. So this part was not there in any
This was not there in any case.
It is a subsequent 13.2 notice.
Absolutely.
Now,
absolutely. Even then, Lordship, out of bona fide, to my own prejudice, but just to show bona fide, I still sought permission from the bank, which was refused. And because they have refused, I have not sold the flat. I have not sold the flat. My lord, therefore, on facts, every point of prejudice sought to be urged is ex facie contrary to the documents on record, which has been recorded as undisputed facts in the previous judgment, which has attained finality, which has not been challenged. The entirety of the argument made now was the same argument made before Honorable Justice Bhattacharya and rejected. That has been accepted by them, therefore can't be re-urged. These are my humble submissions, my lord. I'll put in a short note, my lord.
May I take 2 minutes of your lordship's
My lord,
time?
may I be excused, my lord?
My lord, in reply, re-argued, my lord, an attempt to improve on the case. My lord, I just show, my lord, the admitted default. My lord, will kindly take note of, my lord, the paragraphs of the writ petition. My lord, paragraph 13 at page 6.
Put it in a written notes of argument. Just argue for the purpose of.
Yes. My lord, shows that, my lord, he has, my lord, made this default for, my lord, several months, my lord, for several years. It's admitted position of fact. before my Lord Justice Bhattacharya, my Lord, the situation was different. My Lord, before my Lord Justice Bhattacharya, there was no rejection of his, my Lord, application for restructuring. My Lord, that is evident from his own avowments. My Lord, the allegation was, I did not consider, my Lord, his application. And my Lord, this application for, my Lord, seeking permission to sell the flat, my Lord, that does not come within the ambit of, my Lord, this resolution framework. Resolution framework, my Lord, does not permit me to allow him, my Lord, to sell, my Lord, a mortgage asset. My learned friend is suggesting that, my Lord, my Lord, as a good gesture, my Lord, did not sell the flat. He could not have done that because it is a secured asset. Irrespective of whether there is a 13-2 notice or not, my Lord, the property is mortgaged. He could never have sold, my Lord, the fact otherwise also. And my Lord, my learned friend also, my Lord, suggested that, my Lord, had the loan account been NPA, my Lord, I could not have, my Lord, even considered the application, my Lord, for restructuring because, my Lord, only standard asset, my Lord, can be restructured. My Lord, that is absolutely contrary to what, my Lord, the resolution framework says. It says, my Lord, clause 4, the borrower's account was a standard asset as on March 31, 2021. And, my Lord, he slipped into NPA category in November. So, my Lord, after that, it's not that, my Lord, whenever an account, my Lord, slips into NPA category, he does not become entitled to, my Lord, restructuring. So, my Lord, that, my Lord, his application for restructuring was considered does not necessarily mean that, my Lord, the account was standard. It means that the account was standard as on March 31, 2021. That is the requirement, my Lord, of this resolution framework.
How soon can you file your notes?
Tuesday, my Lord. Tuesday, Wednesday, my Lord. Wednesday.
Yes, ma'am.
Heard learned counsel for the parties, oral hearings are concluded. The matter shall be listed under the heading to be mentioned on July 26, 2023 for the purpose of filing of written notes of arguments by the parties.
My lord, may I make one prayer? My lord, in the interregnum, the respondent bank may not take any coercive steps, my lord.
My Lord, what can follow a 13-2 notice? My Lord,
No, Mr. Banerjee, I'll put that on record. The respondent bank shall not take any coercive measures on the in terms of the impugned communications till disposal of the writ petition.
Grateful, my lord.
My Lord, kindly make this restraint order conditional at least. My Lord, he is enjoying this, my Lord, without, my Lord, showing, my Lord, the color of money.
Let us come back after a few. Wednesday we'll be filing that. So I'll get that weekend. Immediately after that, I'll pass back.
Very well, my Lord. Great.
My lord, we shall also file the pages which from the earlier writ petition. My lord, the
135, 136, same. So file one of the pages.
my lord, they represent two separate plans, my lord. It's a 5-year plan and a 7-year plan.
Oh, very well. Then annex both to the written notes of arguments. And
Great.
exchange copies of the written notes.
Yes, sir.
Grateful, man. Great.
Upgraded matter. Item 9.
Lord, I appear for the writ petitioner. My lord, this is, my lord, a writ petition against basically, my lord, the ROC, that is the Register of Companies, for non-compliance, my lord, and inaction on their part, my lord, for abiding by the orders passed by this court.
Service has been effected, Mr.
Yes, yes, my lord. And my lord, affidavit of service is also on record, my lord. May I file, my lord? Service hoega chalo? Yes, they have received it also, my lord. Main CLB order to go there.
Yes.
CLB order. Well, the main order which my lord needs to see, which my lord gives rise to the cause of action, is 184, my lord, the CLB order as it then was. My lord, kindly comes to 184. My lord, what lordship needs to see is, my lord, B. The appointment, this was, my lord, filed by us, my lord, where we lost the appointment of respondent number 3 and 4, an allotment of benefit of the company, and hence the same are illegal and valid, legal and valid. The removal of the petitioner number 1 to 8 as directors under section 284 of the Companies Act 1956 in terms of the MOU dated 1/6/2010 was done without the process of enforcement of the said MOU through the civil court, and the petitioner's doctors group having 49% shareholding is entitled to be represented on the board of directors under the principle of legitimate expectation, and thereby the respondent number 1 company is directed to appoint such number of the petitioners as directors of the company as are just one number less than the number of directors representing the respondents group having 51% shareholding. And then, my lord, liberty is given to the doctors group to opt and move out of the company at fair valuation. So this was against us. We were asked to leave. Now, my lord, against this, we preferred an appeal. Kindly comes to page 68, whereby, my lord, where the appeal was moved before this honorable court, and ultimate in then, my lord, the 10F provisions were there under the Companies Act. And ultimately, if your lordship comes to paragraph 98,
Page 98, last paragraph.
I may read from page 98 at the bottom. My lord, the Company Law Board, although held that the removal of the petitioner numbers 1 to 8 as directors under Section 284 of the Act was done in contravention of the provisions of the Companies Act 1956 and also against the principle of legitimate expectation, dismiss the company petition. The allotment is also in violation of Article 6 capital B of the Articles of Association. In view thereof, the appeal succeeds and the board resolution dated 31st of May 2013 and the consequent allotment shares in favor of the respondent numbers 3 and 4 are set aside. So entirety goes. The judgment dated 9th May 2006 is set aside. So the entirety of the judgment is set aside. Now, my lord, apropos this, they preferred a review. The review is pending, no steps taken whatsoever. No orders, only filed, never moved even before this honorable court. In 2016. Now, my lord, in view of this judgment, we approach, my lord, the ROC. My lord, kindly sees, my lord, that letter, which is at 205, my lord. My lord, kindly takes, this is a letter as way back on 21st of October 2016 itself. We intimated them. Lordship will kindly come to 206. The relevance are at the bottom, my lord, B, C, D, and E. Mr. Shankar Kumar Sharma, my lord, the DIN number is given, has also under his digital signature filed one Form 2, now PAS 3, for allotment of 5776 equity shares of the company, which is also held illegal. Against the above illegal actions of Mr. Sharma, we had moved a company petition being CP number such and such before the erstwhile CLB Kolkata bench. The CLB, by its order dated 9th of May 2016, held all the above activities of Mr. Sharma as legal. Now, the activities, my lord, are at the brief facts in the same page from the top. It's quoted there. What, my lord, has been, my lord, held to be legal. A copy of the CLB order is annexed. Being aggrieved by the order dated such and such, we have preferred an appeal before the Honorable High Court at Calcutta being ACO number such and such. The Honorable High Court, by the order dated such and such, was pleased to set aside the order dated such and such passed by the CLB. And, my lord, the order was annexed. Now, what is the prayer? Lordship will get it at, my lord, page 208. We have sought for, because this is very relevant, to set aside both the form number 32s as stated herein before in paragraph A small a as listed by Mr. Shankar Sharma, because that has been now held to be illegal. To set aside the form number 2 as stated in paragraph A subparagraph B filed for allotment of shares 5776 equity shares of the company, which has also been set aside by the division bench. To take other steps as may be necessary in the premises for the order dated such and such. Now, my lord, kindly sees, my lord, the hilarious reply given by, my lord, the ROC at page 209. With reference to the subject cited above and your letter dated 21st October 2016 and 24th October 2016, I am directed to state that upon perusal of the Honorable High Court order dated 14/9/2016, it appears that this office has not been made as one of the respondent or no specific direction prayers upon the Registrar of Companies West Bengal in the instant case. Hence, it is therefore requested both the parties of the petition to take necessary action in order to comply with the Honorable High Court order dated 14/9/2016, since the court order is binding upon both the parties in the instant petition. My lord, this only one can say if he has no knowledge and is novice about the Companies Act, with all due respect. Because, my lord, under the old 397, 398,
That is a sufficient threat to the court also.
no, my lord, I only say with regard to this document. And my lord, the present 241, 242, there is no relief which is needed to be
You have
prayed.
challenged this.
Yes.
You want your communication to be acted upon.
Yes. And my lord, the order also says so that they have been held illegal. So what is essentially required, because of which, my lord, I am
If I
going to,
direct the company, the register of companies,
yes,
to,
my lord.
decide your application in terms of the order of the division bench,
And my
irrespective
lord,
of
the
the
press sort out here, my lord, because what is happening in essence, I am now in violation of the statutory provisions of the Companies
So,
Act.
one thing, there may be certain other provisions
Subject
of
to-
law
subject to
in accordance
compliance
with
in
law.
accordance with
Very good. Ashu. Madhavu, order to pass. The grievance of the petitioner is limited. Full stop. Since none appears for the respondents despite service, comma, keeping on record the affidavit of service filed in court today, comma, the matter is taken up for hearing in the absence of the respondents. Full stop. Next para. Learned counsel for the petitioner points out that initially a proceeding was initiated before the Company Law Board under the Companies Act 1956, wherein it was observed inter alia that the respondent number 1-company within bracket therein bracket closed was directed to appoint such number of the petitioners therein as directors of the company as are just within single inverted one number single inverted close less than the number of directors representing the respondents group having 51% shareholding. Full stop. Next para. Since the present petitioners were aggrieved with the same, comma, an appeal was preferred before the concerned bench of this court taking up such matters, comma, giving rise to APO 190 of 2016 within bracket with ACO 74 of 2016. Full stop. A coordinate bench, comma, vide judgment and order dated September 14, 2016, comma, was pleased to allow the said appeal, comma, thereby setting aside the board resolution dated May 31, 2013 and consequent allotment of shares in favor of the respondent numbers 3 and 4. Full stop. The judgment of the
Company Law Board, man.
Company Law Board dated May 9, 2016 was also set aside accordingly. Full stop. Next para. Subsequently, comma, when the petitioners approached the registrar of companies in terms of and on the strength of the order of the appellate court by way of an application making prayers that both the form number 32 small s be set aside as stated in para capital A within bracket small a therein, comma, filed by Mr. Shankar Sharma, comma, to set aside the form number 2 as stated in para capital A within bracket small b filed for allotment of 5776 equity shares of the company and to take any other steps as may be necessary in the premises of the order of the appellate court dated September 14, 2016, comma, the ROC, comma, instead of complying with such request, comma, gave a peculiar reply to the effect that the said office was not made a party before the court and that the parties of the petition were to take necessary action in order to comply with the court order dated September 14, 2016, since the court order was binding upon both parties in the petition. Full stop, next para. The apparent tenor of the order of the Registrar of Companies as communicated to the petitioners on December 22, 2016, was that, since the Registrar of Companies was not a party to the proceeding before the appellate court or before the Company Law Board, the same was not bound by the said orders. Full stop, next para. However, such legal proposition is not, such proposition is not tenable in the eye of law, since the ROC, even if not within bound, close, as a party, is bound to comply with the directives passed therein on the parties, in pursuance of the observations made by the appellate court. Full stop, next para. The orders of the appellate court, as passed on September 14,
2016,
2016, apart from being binding on the parties thereto, are also to be complied with to give effect thereto by the Registrar of Companies. Full stop, as such, the communication, the refusal of the Registrar of Companies dated December 22, 2016 cannot be sustained in law. Full stop. Accordingly, WPA number 9049 of 2021 is allowed, thereby setting aside the communication of the Registrar of Companies dated December 22, 2016 within bracket annexure P7 at page 209 of the writ petition bracket closed, and directing the Registrar of Companies to act to grant the prayers made by the petitioners in their application, which are appearing at page 208 of the present writ petition, subject to compliance of all legal formalities and in accordance with law, in terms of the order passed by the appellate court in APO APO 190 of 2016 within bracket with ACO 74 of 2016 on September 14, 2016.
0528.
Full stop. The parties as well as the ROC shall comply with the directions of this court on the basis of a server copy of this order, coupled with a communication by the learned advocate for the petitioners, without insisting on prior production of a certified copy.
528.
Yes, Mr.
But
Banerjee.
may be not within a time frame of any
So
time.
such entire exercise shall be concluded by the ROC as expeditiously as possible, positively within 1 month from the date of communication of this order to the ROC.
Grateful, madam. Deeply grateful.
Item 10.
Lordship, for the petitioner, this is the affidavit of service we kept on record.
Affidavit of service, that is not an affidavit of service.
Not necessarily, Your Lord.
That is not an affidavit of service. Yes.
Lordship, the petitioner is an association and is primarily concerned with the protection of the rights, interests, and other benevolence of the members of the scheduled tribe. Lordship, by and large, the specific allegation in my application is that a sitting member of parliament who has contested for the post of an MP in the reserved category of a scheduled tribe is prima facie debarred from contesting the elections because he is not a member of the scheduled tribe.
How do you say that?
Lordship,
yes.
According to the scheduled tribes orders,
yes.
1950, the caste identity, page 29, Your Lordship. D, the caste identity. One of the following documents may be accepted. Caste certificate of any relative. 2, copy of the old land deed prior to 1950, specifying the community name in that document. That is on page 19 and 19A. Now, your lordship, 19A,
Yes.
the seventh line, seventh and eighth line from the top, falling within the subcategory of Chasha Kurmi.
Yes.
Now, your lordship, in a spate of several other litigations, which is followed after filing of this writ application, it has been held by this honorable court that Kurmis, Mahatos do not come within the category of scheduled tribe.
I'll direct affidavits in this matter.
Lordship. Lordship, my innocuous prayer is that his certificate should be cancelled and he should be disqualified and debarred from contesting the elections, and or it should be suspended.
Very innocuous.
Lordship.
Very innocuous. Learned counsel for the petitioner contends that the private respondent, comma, being a member of the Legislative Assembly of West Bengal, comma, had obtained a caste certificate on the basis of misrepresentation, comma, to the extent that the updated guidelines in terms of the memorandum dated July 27, 2015, issued by the government of West Bengal, comma, backward classes welfare department, comma, clearly stipulates that one of the following documents therein can be accepted to establish caste identity. Full stop. One of such documents is copy of old land deed within bracket prior to 1950, bracket close, specifying community name in that document. Full stop. In the case of the private respondent, comma, the community name mentioned is within double inverted Chasha Kurmi, Chasha Kurmi, double inverted close, full stop. Next para. That apart, comma, learned counsel places reliance on certain judgments passed by division benches of this court, presided over by the then Chief Justices and the present Chief Justice, comma, which indicate that an inquiry is going on with regard to whether Kurmi stroke Kudmi, Kudmi stroke Mahato are scheduled tribes or other backward classes within bracket B, bracket close, full stop. Hence, comma, it is contended that the private respondent number 5 was not entitled to contest the elections as a member of the Legislative Assembly on the presumption that he is a member of the scheduled castes and tribes. Full stop. Next para. Since an arguable case has been made out by the petitioner, comma, which has locus standi in the matter in view of the same being an association protecting the rights of scheduled tribes and their welfare, comma, the writ petition ought to be heard on its merits. Full stop. Accordingly, the respondents are directed to file their affidavits in opposition within 3 weeks. Full stop. Reply, if any, shall be filed 3 weeks, now 4 weeks. Reply, opposition within 4 weeks from date. Full stop. Reply, if any, shall be filed within 1 week thereafter. The matter shall be listed for final hearing in the monthly list of September 2023.
Lordship, admittedly in this judgment, the State Council
Justice
has...
Srivastava judgment, that was an interim order, a direction for service of copy that was pending.
Lordship,
Justice Shivaganam's judgment, probably that is on.
Lordship, the state has made a declaration that yes, they fall within the category of OBCs and not STs in this particular judgment. If your lordship kindly...
these judgments saw the light of the day after the private respondent.
Yes. After filing this writ application.
Which party is he representing?
Lordship, the ruling party. The ruling party.
Ruling party itself. Now trying to defect.
Lordship, it has come to our knowledge much later because
I'll not pass any interim order on this. Interim order means he won't be able to perform his duties as an MP, as an MLA. I cannot do that. Unless I set aside the caste certificate. That I can very well do, yes.
Your Lordship, may I?
Yes.
Your Lordship, item number 12, Your Lordship, today's list. I'm just praying for not today, Your Lordship, because I have been led by Mr. Abhishek and he has some personal difficulty today. So, Your Lordship, kindly.
You're for the other side.
Yes,
For the petition, my lord. Well, my money has been not withheld for last 6-7 months.
When it is called on for hearing, please
My
make
lord,
this fair.
one indulgence.
When it is called on for hearing, please make this.
Item number next item 11. I am the state advocate. Now I am not the panel. But my lord, as per direction of another court, the affidavit of opposition already.
No,
done
sir.
by
When it is called on for hearing, please mention it so that the petitioner is also present. I can pass.
petitioner also
It's also
present.
there, Your Lordship, in my matter. In item number 12, petition is also there.
Petition is there, but he's opposing.
Well, I have got also some difficulty at 2 p.m. because I have another division bench matter. But my junior will do that because my lord, my
Let us come back.
Kindly,
Lord, 11,
Monday,
11,
there is.
Monday, Your Lordship, kindly fix a time, my lord. Monday. My lord, because my lord,
I won't fix a time. Let us come back at.
But 171 Contact Act they have invoked.
Come back at.
My lord, only I submit the affidavit of opposition.
Item 11.
Yes, you are saying
My
something.
my lord, I was in the panel. At present, I am not in the panel. But as per Honorable Court's direction, the affidavit of opposition done by the HDO, Howrah. This is the original. That's why I am submitting. I have served the copy to the petitioner.
You have served?
Yes, my lord. I have already
filing
the
reply.
Very well. So you cannot appear in the matter.
How can I, my lord? As you
Learned counsel appearing for the state submits that the said learned advocate is no longer in the panel of the state and as such cannot represent the state full stop. However, since the affidavit in opposition directed earlier has already been affirmed, he desires to file the same in court full stop. The affidavit in opposition filed today be kept on record, along with the affidavit in reply filed by the petitioner full stop. On the prayer of learned counsel, on the prayer of learned erstwhile counsel for the state, the matter is adjourned for a week.
2 weeks, my lord. Right.
For 2 weeks, they may have some urgency. Yes, you have any difficulty if it's adjourned for 2 weeks?
For a week.
Adjourned till July 27, 2023, when it will be listed under the same heading.
Grateful, my lord. It is my moral duty, my lord. And that's why.
No, thank you so much. Yes.
Again, I served the copy of the application upon the government leader.
Nothing. Those stages are over. Now they have to argue only, whoever is on.
Grateful, my lord.
Item 12.
My lord, I am for the petitioner, my
Right.
lord.
What about service?
My lord, actually, my senior is on stand on legs, so may I
Your
start?
senior?
Is stand on legs in the division bench at the matter fixed, my lord?
Start
May
the
I-
matter, yes. Item dispatched is not good service.
My lord, before sometimes ago, before you're raising, my lord, one lady advocate was come and just started intimated you that they want to take the not today, and now it has already been served, my lord.
But if they're not there, I cannot take up the matter. Then please come back tomorrow. I'll keep it tomorrow. I say nobody appears for them. But your service is not complete. Keep it with you. If they
So on my lord, kindly fix the matter on Monday, my lord. at any
on the way,
time.
then file the service. Affidavit of service filed today be kept on record. Full stop. None appears at the time of call for the respondent. Full stop. It does not appear from the affidavit of service that proper service has yet been completed on the respondent. Full stop. Let the matter stand adjourned till July 24, 2023. Monday. Uh-huh.
Okay.
13.
Well, I'm for the petition.
Yes.
My application is for praying for the issuance of permission for manufacturing.
Service.
We have served. So no. Delivered.
Good. For issuance of
Permission to manufacture e-vehicles, auto rickshaw, e-rickshaw, e-loader, right? Though we have got all the necessary permission and certificate from the statutory authorities. The other state like Rajasthan and Jharkhand, they have also approved. Now, here the impediment which I have gathered was one injunction order which was passed by the Alipur court. It was regarding the patent right. If Lordship may kindly come to page 158. The type copy of the certified copy, Lordship may kindly come to 158. This is the order dated 24th February 2020. Title suit number 27/2018. The consideration of this order, if your Lordship may kindly come to page 160.
Yes.
The first paragraph is the order passed by the Honorable High Court in the in CS number 380 of 2014. Lordship got it. Now,
yes.
Subsequently, the order got modified. And the Honorable High Court in the CS 388, I mean, my Lord Justice Shomenchen was there.
Yes.
Page 169, it's reported. This is CS 388, Lordship will find it. Page 169 on the top.
Right, right.
I'll just straight away to take your Lordship to the relevant part of the observation and the finding of the Honorable Court is page 182. Paragraph 64.
64, yes.
The applicants are already in the trade and have been manufacturing and selling their battery operated electric cycle rickshaw. The applicant has raised serious issues with regard to the validity of the patent. I am prima facie satisfied with regard to the invalidity of the patent. Under such circumstances, the interim order passed on 17 June 2015 is recalled, subject to the conditions indicated below. Now, the conditions were in paragraph 66, Lordship. The applicant shall furnish true and faithful quarterly statement of accounts to the Registrar Original Side High Court at Calcutta with regard to the business in relation to the device apparatus already manufactured by them since inception. The initial statement shall be from the date it commences business, duly certified by its auditor. The subsequent statement of this quarter shall be furnished within the 15th day of succeeding month. The applicant shall find an undertaking by way of affidavit to pay the damages if at the final stage the court arrives at the finding that the applicant has actually infringed the patent of the plaintiff. So there is no impediment now, Lordship. Only this undertaking
was the injunction against whom?
Against the another company. This is another company, but the subject matter was that he was enjoying the patent right of the e-rickshaw. So that was based on the earlier order of the Honorable High Court. The learned
But that order could not be in rem. So how could it be a relevant factor for this?
I'm coming to Lordship. Thereafter, another company, they also approached for the registration of the vehicle before the Honorable Court by invoking the rejurisdiction, Lordship. That is page 161. Annexure P8.
Yes. 161.
161. 161.
161 is the order of jurisdiction.
No, no. Jurisdiction order is page 169. Page is wrong.
No, no. 161 is another
writ.
What? This is a different writ.
Different with another person.
Yes.
Same issues were raised there, and my lord was pleased to allow the writ petition. On that will come. That is relevant from page 164.
Yes.
The third paragraph. The other orders shown to the court, including the PIL dated 17 August 2018, do not indicate any existing embargo on the registering authorities to register e-vehicles of concerned entities. The affidavit of undertaking shown to the court.
Registering authorities to proceed with registration.
That is the only my nothing.
So your registration is not being, application is not being processed.
Not been processed, not been considered. Flying. We have given representation also. That's all. All other requirements we have fulfilled. The other state I can show you from my annexure, Lordship, which they have also accepted my e-vehicle, Lordship. I can show you, Lordship. Kindly
show me their refusal, Mr. Kasumuddin.
They have not refused. They have not acting. They are not giving any response.
What is your application?
Page number?
183 letter by the company and 188.
Page 83 is my annexure P10, Lordship. This is my representation. And thereafter, page 188, the advocate's representation also. Not yet been considered. No response.
You want a registration of your vehicle?
Registration of my vehicle. The other state of Rajasthan, Jharkhand, Telangana, Bihar, Odisha, everybody has granted me. But here, there is a problem.
Despite service, none appears for the respondents. The affidavit of service filed today be kept on record. Stop. The grievance of the petitioner is that the petitioner sought for registration of an e-vehicle within bracket electronic vehicle bracket closed, comma, which is not being processed by the respondent authorities. First up, it is contended that the premise on which the same is not being processed is apparently an order passed in title suit number 27 of 2018 and an order passed by a coordinate bench of this court, comma, granting injunction in that regard. Full stop. Next para. Learned Counsel places the order dated February 24, 2020 in title suit number 27 of 2018, passed by the 13th Court of Additional District Judge at Alipur, comma, where the petitioner was not a party, comma, in which, comma, it was observed that the order that an order of injunction was passed restraining the respondents from repeating any infringement of the patent of the plaintiff therein. Full stop. Next para. Learned Counsel, comma, however, comma, also submits that the same was passed on the basis of an order of a coordinate bench of this court passed in CS 388 of 2014. Full stop. However, comma, subsequently, the said order of the coordinate bench was also modified and the injunction order was recalled subject to certain conditions being stipulated. Full stop. It transpires from paragraph number 66 of the said judgment passed in Jasper Motors Private Limited and another versus the proprietor, comma, Basanti battery operated rickshaw and others, reported at 2018 SCC Online Cal 4795, that the court observed that the applicant therein shall furnish true and faithful quarterly statement of accounts to the registrar original side of this court with regard to the business in relation to the device stroke apparatus already manufactured by them since inception. Full stop. Apart from that, comma, certain other riders were also imposed, comma, subject to which the interim order dated June 17, 2015, comma, on which the civil court relied, comma, was recalled. Full stop. Next para. Bare perusal of the said order of the coordinate bench indicates that the conditions stipulated therein do not affect the present petitioner or any other non-party to the said litigation at all. Full stop. That apart, comma, Learned Counsel for the petitioner also places reliance on another coordinate bench judgment, comma, passed by a different learned single judge on September 29, 2022 in WPA 22109 of 2022, comma, also between third parties, comma, where it was observed that the other orders shown to the said court do not indicate any existing embargo on the registering authorities to register e-vehicles of concerned entities. Full stop. It was further observed that the court was not inclined to accept the contentions of the private respondent therein to enjoy with certain rights for restricting the petitioners therein from registering their e-vehicles. Full stop. The court went on to observe that the private respondent therein would be at liberty. Went on to observe that the registering authorities are directed in the meantime to proceed with registration of e-vehicles of the petitioners therein in accordance with the applicable statutory provisions. Full stop. Next para. Learned Counsel for the petitioner also contends that certain other states are also permitting registration of e-vehicles. Full stop. Next para. Upon a comprehensive perusal of the materials annexed to the writ petition, comma, it is clear that there is no embargo on the writ petitioner's application for registration of e-vehicles being
E-loaders. Sorry, e-vehicles and e-loaders.
And e-loaders and e-loaders being processed and acted upon by the respondent authorities. Full stop. Since there is no impediment in registration of e-vehicles and e-loaders, comma, the writ petitioner's application for such purpose should also have been processed expeditiously. Full stop. Accordingly, WPA 6458 of 2023 is disposed of. Which authority should, which respondent?
Which is,
no particular authority.
no,
Directing the respondents to ensure that the petitioner's application for registration of the petitioner's e-vehicle stroke e-loader be processed expeditiously and appropriate registration be granted to the petitioner, comma, subject, comma, of course, comma, to compliance of all due legal procedure and formalities by the petitioner. Full stop. Such entire exercise shall be completed by the respondent authorities as expeditiously as possible, comma, positively within 2 months from the communication of this order to the said authorities. Full stop. The parties shall act on a communication by the learned advocate for the petitioner, coupled with a server copy of this order for the purpose of compliance. No rest to cost.
Deeply obliged, Lordship.
Thank you.
Grateful, Lordship.
I beg to appear on.
You're for petitioner, you're for the bank. Yes.
For the respondent number 5, Lordship.
Yeah,
Led
for
by
five.
Amita Bajamar.
Both the affidavit of service, my lord, initial service and thereafter, my lord, prior to mention.
Yes,
My
Mr.
lord, the petitioner number 2 is the, my lord, administrator of a aided, my lord, Christian, my lord, school. My lord, this is, my lord, Christian minority education institution, my lord, mainly promoting, my lord, the education with regard to scheduled tribe, scheduled caste, my lord, the backward caste classes people.
Right.
Now, my lord, they have, my lord, the 4 accounts under the PNB Bank, my lord, Punjab National Bank. These accounts is not mainly getting aid from the government, my lord, for different heads. My lord, these 4 accounts was used to run by the administrator and teacher in charge of this school. My lord, may I give your lordship the idea? My lord, the Shobita Das, the assistant teacher, who was appointed in the year 2008, she was became the Shobita became the teacher in charge in, and he was 1st of January 2022. He was became the teacher in charge. Then the Shobita and administrator used to operate as per the norms, the entire 4 bank account maintained by the PNB Bank. Now, a resolution was taken, that is at page 17 of my lord's brief, that was passed on 1st of June 2022. The appointment of Shobita was being terminated by virtue of that resolution. And in place of Shobita, Choitali Sheet was being appointed as teacher in charge. Subsequently, on 18th July 2022, at page 20 of my lord's brief, the DI approved the appointment of Choitali Sheet to be a teacher in charge. Ultimately, after appointment of Choitali Sheet to be a teacher in charge, a resolution was being passed by the institutor, that is at page 21 of my lord's brief, 22nd of July 2022, thereby giving the authority to act the Choitali Sheet as well as to operate the signatory, authorized signatory to operate the bank account. Now, these 4 accounts are not being substituted.
Who gave this authority?
That is the resolution.
The stamp is smudged.
Yes.
Pralay Kumar Sheet, her husband.
Pralay Kumar Sheet, is the petitioner number 2, the husband.
I guessed correctly, yes. He is also in the school.
Yes, he is the administrator of the school. He was there from the beginning. He was there from the beginning. But here, regarding the removal or appointment of Choitali, that has been approved by DI.
Right.
So, that chapter.
You had no hand
yes,
in that.
Yes. So, we have requested the Punjab National Bank to allow the current teacher in charge, being an authorized signatory, to operate the bank.
PNB also asked the same question as I did.
I do not know what
They have not been
given.
permitting. Yes. What is your stand?
Lordship, but they have only served us a copy of a representation along with this board resolution. There are other documents that bank needs in order to remove a name and to incorporate the name and more.
Documents disclose.
My lord, the documents that her own identification documents, and my lord, she has to be present there by herself, my lord, and moreover, her appointment letter, which was not given, my lord, and that the erstwhile Shobita Dash.
Termination of Shobita is disclosed in the writ petition.
And the termination of Shobita Dash. That has to be given in
So
order.
her identification documents,
Lordship.
the appointment, her appointment letter,
Her
and
appointment
Shobita's
letter.
removal.
Lordship. This will suffice. And if there is no discrepancy, my lord, we will check.
Everything is disclosed in the writ petition. Again, my lord, I shall give.
But that was
Whatever
not
they
given to the bank, my lord. That could
Because
be evident
my
from the.
appointment, that has been ratified by the DI. Everything I have disclosed.
Produce the originals before the bank,
Yes,
along with the
Not
learned counsel for the petitioner submits that one Choitali Das, the wife of petitioner number 2, was appointed as a teacher in charge of the petitioner number 1 school, upon removal of the previous teacher in charge, namely Shobita Das. Full stop. The documents with regard to the removal of Shobita and appointment of Choitali have been annexed to the writ petition. Full stop. Next para. Subsequently, the appropriate approval was granted by the school, comma, through its admin,
That is by the concerned district inspector of schools, DI.
comma, as further approved by the district inspector of schools, comma, to operate the bank account of the school held with the Punjab National Bank, which is the respondent number 1 bank. Full stop.
Number 2 to
The approval is being granted with respect to his appointment as TIC, and thereafter the school's resolution.
আগের সেন্টেন্সে কি বললাম বলো, গোড়া থেকে বলো, পুরোটা কেটে দাও, আমি বলে দিচ্ছি করে নাও, তার চেয়ে ছোট হবে। The petitioner's case is that one Shobita Das was initially the teacher in charge of the petitioner number 1 school, full stop. On her removal, comma, subsequently, comma, one Choitali Das was appointed as the teacher in charge, full stop. Such appointment was approved by the inspector of schools, district inspector of schools duly, full stop. Thereafter, comma, Choitali, comma, the newly appointed teacher in charge was authorized by the school to operate all sorts of bank accounts of the institution within bracket school, comma, jointly with the administrator, that is the petitioner number 2, comma, who is, comma, coincidentally, comma, the husband of the said Choitali. Full stop. Next para. However, comma, it is alleged that despite the petitioners having approached the concerned bank, that is the respondent number 1, the Punjab National Bank, comma, the said bank is not permitting such operation by Choitali jointly with the petitioner number 2. Full stop. Next para. Learned counsel for the respondent bank submits that a bare representation was filed with the bank without the necessary documents required for permitting such operation by Choitali along with petitioner number 2. Full stop. On the query of court, comma, learned counsel for the bank, comma, on instruction, comma, submits that the said Choitali sheet has to be present herself before the bank authorities along with her identification documents, comma, appointment letter and necessary documents in that regard, comma, as well as the documents pertaining to the removal of the erstwhile teacher in charge, Shobita Das. Full stop. Next para. If such an approach is made, comma, there is no impediment on the part of the bank upon verifying such documents, comma, to permit the said Choitali Das to operate the account jointly with petitioner number 2. Full stop. In view of such fair submission by the bank, comma, WPA 7225 of 2023 is disposed of by directing the petitioner number 2 to ensure directing the petitioners to ensure that the said new teacher in charge Choitali Das, comma, along with petitioner number 2, the administrator, comma, shall present themselves before the respondent number 1 bank with necessary documents pertaining to identification of Choitali Das, comma, her appointment letter and other documents pertaining to her appointment, comma, if any, comma, and the documents relating to the removal of Shobita Das as teacher in charge. Full stop. As and when such approach is made during the regular office hours of the bank, comma, the respondent number 1 bank shall verify such documents expeditiously and at the earliest thereafter permit the said Choitali Das to operate the account of the petitioner number 1 school with the said bank along with petitioner number 2 administrator. Full stop.
My lord, may the respondent number 4 be given the direction, that is the branch manager, Punjab National Bank, Bhimpur branch.
It is made clear that the directions on the respondent number 1 shall also be binding on the respondent number 4, which is the branch manager, who is the branch manager of the Punjab National Bank, comma, Bhimpur branch. Full stop. No address to cause.
I'm grateful to
This is not Choitali Das is being recorded. It should have been not sheet. Choitali.
Choitali Das. Shobita Das. Choitali sheet.
I'm grateful to your
একই বানান sheeter. Yes.
15.
After the private respondent.
Yes, Mr. Ghosh. Service.
After the private respondent.
Lord, I appear for the petition.
that I'm being led by.
You have
Mr.
to show
Vishnu
service then
Bhatt.
on the
Yes,
other respondent.
Yes, no service,
No service.
no service. No service.
Yes.
It was served long back, upgradation, no notice.
No notice, that is it.
But I appear for my lord, respondent number 2 register. It's a cooperative matter.
What is the matter?
Lord, the petitioner, my lord, here, the short point of it is he alleges.
Mr. Ghosh, are you ready in the matter?
Yes, yes. He alleges that he is one of the co-owners of a flat in a cooperative housing society. And my lord, the
LMB, I probably appeared at some point of time for LMB. Name is very familiar.
then my lord,
I don't know whether I dealt with some litigation as a judge or do you have any instruction that I appeared at any point of time?
no, my lord, let me clarify.
He was not born then.
My lord.
Your learned advocate and record was not born when I appeared.
Yes,
Even
and
fair. So whether the society was born then, I don't know.
my lord, it seems that my lord, it was long back in 1993 that the
Please ask your client and come back tomorrow. It will continue to appear under the heading upgraded.
Not tomorrow, lordship.
Very well, on Monday.
Tomorrow very uncertain, lord, for us.
Wherever it's.
I will be there.
You'll be joining, Mr.
No question. But I may not even with my full intention. I may not.
But you appear for the state also. You should join.
No, normally I do not.
Very
Grateful.
In order to enable learned counsel for the petitioner to take instruction as to whether I had appeared prior to elevation for any of the parties in the matter, the matter is adjourned till July 24, 2023, when it will be listed under the same heading. So upgraded as upgraded matter.
Grateful, lordship.
Grateful, lordship.
I might have taken up the matter as a judge also, but the name is very
The
familiar.
name is familiar.
Please take instructions.
understand.
Unnecessary.
My lord, the cooperative
embarrassment.
society is also a party. I'll also try to get my lord information from
yes.
them.
Oh, you are not the cooperative society.
I am the petitioner who claims against.
Mr. Ghosh, you also take instruction.
Yes.
No, society should come also because their main
Society
content,
should actually inform me.
because main contents and lord relates to
Learned counsel for the petitioner বলেছে কি?
relates to
To enable learned counsel for the parties করে দাও।
because
the prayer I have no objection.
Because
the pleadings I have objection.
no society should be here because their main
No, Mr. Ghosh, just take instruction whether I appeared.
Yes, yes.
Otherwise, 2-minute matter, we can go.
grateful.
Pardon?
Yes.
Society should be here
Yes, that is true.
That is the reason, yes.
because the parking space has to be decided by the owner of society. Therefore, there.
Yes.
I'll decide everything. Their parking space, residence, everything. You said like just come back with
on
details.
Monday. Yes. Very well.
Grateful.
16.
Yes, Mr. Chanel.
Lordship, in this matter, I am appealing for the
You are for the
petitioner,
respondent.
Lordship. After filing of the writ application, some development has been occurred, Lordship. Suit has been
Development?
Development has been occurred, Lordship. Now, the suit has been filed, Lordship. We have filed one supplementary affidavit.
I don't
Lordship.
understand. Development has been?
Development has been happened, Lordship. Suit has been filed by the writ petitioner, Lordship, for cancellation of a deed, which has been challenged in this writ application, Lordship, regarding the valuation. Now, Lordship, I have filed supplementary affidavit, Lordship, without your Lordship's leave. May I submit?
Get the leave.
Yes.
Yes. Leave is granted, but give them a copy.
Yes, Lordship, I will.
Why two?
One affidavit of service, Lordship.
What is the matter, Mr. Chanel?
Now, Lordship, the petitioner is a Lordship, 86-year-old person, Lordship, suffering from cancer. Lordship, urgent need of money in their 2020, Lordship, she decided to sold some property. Lordship, actually, he has, Lordship, 18 decimals of land, out of which he decided to sell, Lordship, 4.5 decimals of land. Now, Lordship, at the time of Lordship registration, he signed in the documents before registration. After the registration deed was, Lordship, he perused the registration deed. It was found that the entire schedule was changed. Entire 18 decimals of land was included in the sale deed. And the valuation, Lordship, which was assessed as the valuation of the property, showing that the building standing on the said property is 800 square feet. When, Lordship, actually the property is, Lordship, the building, two-story building is measuring about 5,000 square feet. Now, Lordship, considering the fraud, Lordship,
It was shown to be 800 or 8,000?
it is actually, Lordship, 5,000.
Shown to be?
800. According to 800, the valuation of the property was assessed. Thereafter, the registration was done. So thereafter, Lordship, considering the fraud, Lordship, petitioner initially made a complaint. FIR was lodged against inaction of the police authority, Lordship. The police inaction writ application was filed before this Honorable High Court. During pendency of the writ application, Lordship, they filed the charge sheet. Thereafter, Lordship, what happened, Lordship, I filed an application before the concerned additional district sub-register for assessing the valuation, because your Lordship knows that as per the 47.
You are wanting it to be increased.
For a properly assess of the valuation.
Your
Because it
allegation
is undervalued. What I am praying, Lordship.
How are you affected? What is your locus standi?
Because, Lordship, I have filed the suit. Now, for the cancellation of the deed, Lordship, the valuation of the statement, valuation statement of the said property is required. Now, Lordship, your Lordship knows
Apply
that
for a valuation statement online also you can apply.
I have already applied, made representation before the authority. That should be decided in terms of my representation. That is my only prayer.
This is neither here nor there, Mr. Shanal. Why should I mean, what is the occasion for the registering authority?
Because, Lordship, the registering authority, Lordship, as per the section, Lordship,
registering authority proceeded as per this deed.
As per their statement, because, Lordship,
The deed, that is the only
in the
thing on which
statement
the registering authority, Mr. Shanal, has to proceed on the basis of a deed which is presented. Only that.
which is presented.
Yes.
Now,
The
Lordship,
registration authority should not go there and verify whether the property.
no, now, Lordship, in terms of, Lordship, section 33 of the, Lordship, Stamp Act,
yes,
they must be, Lordship, made the statement, Lordship, truly regarding the consideration and the, Lordship, sales description. According to them, their statement, Lordship, the registering authority, Lordship, assess the valuation.
This is a
Now,
bad matter.
now, Lordship, I am praying only on the consideration on the part of the valuation of the property, because, Lordship, my suit is for cancellation of the said deed on the ground of fraud and undervaluation. Your Lordship, in the previous occasion, Lordship, in a 227 jurisdiction, pass on judgment regarding that if the valuation, Lordship, is shown by way of fraud, subsequently it cannot be reassessed. Because I have already filed the suit. Suit is for, Lordship, cancellation of the deed. Supplementary affidavit after the.
This depends on the result of the suit.
Result of the suit. Now, Lordship, kindly consider my prayer, Lordship, regarding the petitioner is 86 years old now. Now, Lordship, is in the suit, Lordship, it
Simply
is
for
same.
that reason, you will be giving trouble to others. Just because you're 86 years old and you have cancer. That does not give you a right.
Cancellation on the prayer of, Lordship, fraud and fraud, Lordship, on the ground of, Lordship, undervaluation is
fraud litigation is pending, criminal case is pending.
Criminal case is pending. That is separate aspect, Lordship. I am not praying anything, Lordship. But so far as the,
Only
Lordship,
thing which can be seen by the registrar is the deed, which is
deed, it is undervalued or not.
Yes.
That is, I am praying before your Lordship to consider the representation, Lordship.
You have to approach the registrar within a reasonable time. When was it registered?
It was registered in the, Lordship, 23rd February.
Which year?
2020.
3 years back.
3 years back.
Now you are coming up with this. No question of this.
Because,
What is the scope?
because, Lordship, the FIR was lodged. Because my limitation period, Lordship.
You are trying to both strengthen that by virtue of this. You are trying to fish out evidence. No.
It can be, Lordship, considered for the, because the valuation statement, which the authority, Lordship, assess.
Yes, what do you say? You have purchased.
Yes, my lord. My lord, whatever has fallen from your lordship, my lord, that is my submission.
Yes, Mr. Shanal.
Kindly consider one thing, Lordship. I mean, I am, Lordship, praying only one thing,
On the
Lordship.
same self cause of action, one mandamus appeal is pending, 3 writ petitions have been filed, 1 civil case has been withdrawn, another civil case is pending, 4 FIRs are run. That's all.
I am in this writ application. My only limited prayer is, Lordship, to assess whether the deed is undervalued or not. Now, Lordship, in the suit, Lordship,
Exactly the same thing which your lordship has already observed. They are trying to fish out anything from each and every case.
It will not be, Lordship, fishing out of evidence.
The counsel for the petitioner submits that the petitioner is about 86 years old and is suffering from cancer. Full stop. It is contended that the petitioner has filed a suit for declaration that transfer deed allegedly executed by the petitioner is a fraudulent one. Full stop. Next para. In that regard, comma, the suit is still pending. Full stop. Next para. In the present writ petition, comma, the petitioner has sought a direction on the concerned registering authorities, comma, to consider the representation of the petitioner. Full stop. although the representation is couched in an innocuous form, comma, the same virtually seeks to upset an assessment of stamp duty and registration costs, which was made by the registrar about 3 years back in the year 2020. Full stop. The said query pertains to the same deed, comma, which has been challenged before the civil court, comma, which challenge is still pending. Full stop. Next para. The petitioner alleges in the representation and in the writ petition that the registering authority erroneously assessed the payable duty, comma, since the sale deed fraudulently showed the property involved therein to be of 800 square feet.
800 square feet.
800 square feet, comma, whereas the actual area of the property is around 5,000 square feet. Full stop. Next para. It is contended that the registering authority is duty bound in law to consider such objection taken by the petitioner. Full stop. Next para. Learned counsel, you are for the private respondent, obviously. Learned counsel for the private respondent submits that at least 4 other writ petitions and several
Three writ petitions,
yes,
one mandamus appeal, one civil case has been withdrawn, another civil case is pending, and 4 FIRs.
at least 3 other writ petitions were filed, comma, along with a mandamus appeal, comma, a previous suit which was withdrawn. Full stop. Moreover, comma, 4 FIRs have been registered at the on the complaint of the petitioner on the self-same cause of action. Full stop. It is further submitted that it is beyond the jurisdiction of the registering authority to make such inquiry as sought by the petitioner after 3 years. Full stop. That apart, comma, the said representation has been made only to manufacture evidence for the purpose of the pending suit and to collect evidence. Full stop. Next para. Heard learned counsel for the parties. Full stop. There is substance in the contention of the private respondent. Full stop.
Lordship, one thing, Lordship, the suit filed, the writ petition which has been stated, Lordship, filed on the separate ground. It is connection with, Lordship, electricity matter, Lordship, theft of electricity.
Next para.
Kindly record my submission.
Learned counsel for the petitioner, comma, although seeking to distinguish the causes of action of the other writ petitions filed by the petitioner, comma, one of which apparently pertain to an electricity dispute, comma, even apart from such consideration, comma, the present representation or writ petition is not maintainable. Full stop. Next para. First, comma, it is first, comma, the petitioner has no locus standi to resile from the assessment made 3 years back by the registering authority on a deed which has been impugned by the petitioner in a pending suit, comma, asking for a reassessment of the said duty. Full stop. Next para. That apart, comma, it is dehors the authority and powers of the registering authority to traverse beyond the subject matter and its measurements as shown in the deed sought to be registered, comma, for the purpose of assessing stamp duty and registration fees. Full stop. Next para. It is not for the registrar, comma, within the ambit of the Registration Act, comma, to go around inquiring in every case of registration as to the actual physical measurements of the property. Full stop. The registrar's duty is merely to see whether the requirements under the Registration Act and allied regulations are complied with. Full stop. There being no allegation on such score, comma, the representation of the petitioner need not be inquired into by the registrar. Full stop. Next para. That apart, comma, the private respondent is absolutely justified in suggesting that the entire exercise by the petitioner, comma, which is the subject matter of the present writ petition, comma, is for the purpose of manufacturing evidence to help the case of the petitioner in the pending suit challenging the deed in issue. Full stop. Next para, such roving inquiry by the petitioner, comma, irrespective of the age and ailment of the petitioner, comma, cannot be justified under any pretense of advanced years or disease. Full stop. Next para, hence, comma, the relief sought in the writ petition cannot be granted. Full stop. Accordingly, WPA 12328 of 2023 is dismissed on contest without an orders to cost. Supplemented affidavit and affidavit of service
Lordship,
filed
only-
be kept on.
Only one prayer, Lordship. the
Nothing
civil
in
court
these orders shall
influence-
prejudice the rights and contentions of the parties in the other pending litigations, including the civil suit pending between the parties.
Great.
Civil suit মধ্যে bracket
Liberty to take.
only one suit is pending. Suit.
One suit is
Civil
paid.
suit. Liberty to what?
Liberty for before the learned trial, take according steps, appropriate
this-
steps before the learned
this-
trial.
What step?
Expeditiously.
I'm expecting another civil suit and 2 more
For what?
FIRs.
Only.
My lord, for the time being.
Astrologer.
I'm expecting a change of Mr. Shanal as advocate.
17.
দিয়ে দিচ্ছি।
Lord, I am for the petitioner.
Lord, I am for the CSC. Private respondent number 6 and 7.
Right.
My lord, I purchased my residential flat from the private respondents. There was an old service connection. The private respondents on their own disconnected that connection. I applied for new connection. My lord, I deposited the requisite fees. Then CEC came. The private respondents are creating hindrance to them.
You purchased the entire property?
One flat, my lord.
Yes, private respondent.
My lord, till date, he is enjoying the electricity. And my lord, he is paying the electricity charges.
You disconnected your connection?
Never. This is, my lord, the completely false allegation, and it was also.
You have sold the property?
Yes, my lord.
So what is your locus to maintain that connection? It's standing in your name still.
My lord, that is a flat, my lord.
Yes.
And my lord, kindly,
He wants a separate electricity connection to the flat.
Statement in the paragraph 5 and paragraph 8 are contradictory itself, my lord.
Let us see that.
Kindly see paragraph 5, page 4, my lord. Your petitioner states that after the purchase of the aforesaid flat, the aforesaid existing service connection was disconnected by the board due to fault on the part of the vendor of the petitioner, as on consumption charges was not paid. Subsequently, the aforesaid service connection was disconnected by the Calcutta Electricity Supply Company. The petitioner lodged general diary such and such. My lord, it was never disconnected. Until day he is enjoying the electricity connection.
Para 8?
lord,
What is the contradiction in para 8?
Para 8, my lord, kindly see the page 5 portion, my lord. The private respondent neither allowed them, the main and agent of the state respondents, to remove the previous service connection, nor allowed them to affect the service connection in any way. The petitioner was further advised to arrange for access of supply position. So, my lord, it is their statement in paragraph 5.
He did not allow to remove the apparatus.
To the CSC.
Page
And-
43, my lord.
And not only that, my
Yes.
my lord, one other thing, my lord, that premises now they are using as a political party office, my lord.
Not your political party. Not
My
your
lord-
political party, the
so my
private
lord-
respondent's political party, some other party.
My
What is
lord-
your objection to
my
that?
lord,
They may do it for whatever purpose.
Yes, my lord, that is objection, my lord, regarding the section. In what purpose they have applied and enjoying.
Political purpose is not allowed.
Yes,
Then?
in that purpose, my lord, that should be the commercial, my lord, commercial.
Unless a lantern or a candle is the symbol of the party.
Yes, my lord.
Otherwise, they are entitled to electricity.
Yes, yes, kindly see.
What is this?
Kindly see the address. Name of the political party.
So what do you do with this?
Address, kindly see the address. In the same address, that is the same flat which is enjoining, my lord.
So what?
That is, my lord,
After selling the property, you have no locus standi.
My lord, my submission, my lord, till date, my lord, my allegation against me are totally false, my lord. Not only that, my lord, they have one after another criminal case was filed before the appropriate criminal code, my lord. They are, my lord, I don't know, my lord. Kindly see the section 42, 5 and 6, and my lord, the
Yes.
Section 135E. Section 135 1E, my lord.
Which should I see first?
My lord, 135 1E.
1E, yes.
Theft of electricity. Whoever dishonestly, my lord, E, use the electricity for the purpose other than for which the usages of electricity was authorized, so as to obstruct the and consume the use of electricity shall be punishable with the imprisonment for a term which may be extended to
What
3
was the
years.
original purpose? For some spiritual purpose.
So, my lord,
Originally, it was
my
being
lord,
used for what? Now politics. Previously, what?
my submission is this, my lord. My lord, that is, my lord, for not for, my lord, the commercial purpose.
Politics is not commerce, unless you admit that politics is commerce.
Well, that is the political party office of the political party.
So that is also commercial purpose.
Yes. And my lord, what is the, my lord, that is not for the commercial
Yes,
purpose,
yes, yes.
which meter is already there.
42, whatever.
And
42.
42, 5 and 6, my lord. Every distribution license shall within 6 months from the appointment date or grant of license, whichever is earlier, established a forum for redressal of grievances of the consumers in accordance with the guidelines as may be specified by the State Commission. Any consumer who is aggrieved by non-redressal of his grievances under subsection 5 may make a representation for the redressal of the grievances to an authority to be known as ombudsman, to be appointed or disengaged by the State Commission. So, my lord, my submission is this, my lord, that before coming into the writ court, my lord, the alternative remedy is there. That should be exhausted at first, my lord.
Yes,
And my
Mr.
lord, the
My lord, the petitioner.
Something else is also there. Yes.
and my lord, the regulation 14, my lord. The regulation 14, my lord, that is the West Bengal Electricity Regulatory Commission, my lord. My lord, after placing that, I shall handle. Effect of splitting of load. If any applicant intending to consumer submits any application for new connection with the intention of splitting of the load to be obtained the benefit of lower charges or furnishes wrong, inaccurate, false statement, his application will be liable to be rejected under the provision of the Act or the regulation made thereunder, and 25% of payment deposit is already made by him by way of charges for obtaining new connection in terms of this regulation shall be forfeited by distribution licensee before the rest of the charges is refunded to him.
Why
So,
do you
my
say
lord,
this is splitting of load? Why splitting of load? What thou?
my lord, when there is an existing connection is there, they have applied for again new connection. That is also the prayer of the writ petition, prayer A, my lord. So, my lord, how it is possible?
Now we'll hear the CS. Yes.
Because the new connection has been sought for in place of the old connection, because the petitioner has purchased the flat from the deceased mother of the respondent number 6. And my lord, she is still being catered with the domestic meter. And my lord, admittedly, she has complied with all the formalities, but the old apparatus needs to be removed before we can go for a installation of a new meter.
No,
For
old,
that, we have
old connection has been disconnected already.
No, we have not disconnected. As per our records, the connection is live, though my lord, 2 months bill is due. So my lord, that particular old apparatus needs to be removed, my lord, and for that we have approached, but we have been physically resisted. So my lord, we need police assistance to go ahead with the work.
Yes, you said disconnected.
My lord,
CSC Limited is not saying
disconnected.
they have not disconnected.
My lord, as per my
records, my lord.
Yes,
meters
as
are
per
live.
your.
as per my instruction, my lord, it was disconnected, and for that, my lord, the petitioner also submitted representations.
CSC is not doing it. Anyway, Madhav Torn. Learned counsel for the petitioner. Learned counsel for the petitioner contends that the electricity connection which was there at the premises in question, comma, which has since been purchased by the petitioner, comma, was disconnected. Thereafter, the petitioner sought a new electricity connection in the petitioner's name, comma, which is not being given by the CSC Limited, comma, apparently due to the objection by the private respondents. Next para. Learned counsel appearing for the private respondents opposes the prayer made in the petition. It is submitted on behalf of the private respondents that there was no disconnection at any point of time, and the petitioner is still enjoying electricity from the existing connection at the premises. For next para, it is further submitted that the petitioner is not entitled to seek a new electricity connection in view of section 135 read with section 42 of the Electricity Act 2003. First up, it is argued that within the contemplation of section 135 within bracket 1 within bracket small e comma, whoever dishonestly uses electricity for the purpose other than for which usage of electricity was authorized, comma, is committing theft, comma, which is punishable under the 2003 Act. First up, in the present case, comma, after taking possession of the premises, comma, the petitioner is using the same for the functioning of a political party, comma, which is not the original purpose for which it was used. First up, hence, comma, it is submitted that the petitioner is guilty of theft. First up, next para, that apart, comma, within the contemplation of section 42 within bracket 5 and 6 of the 2003 Act, comma, every distribution licensee shall within 6 months from the appointed date or date of grant of license, comma, whichever is earlier, comma, establish a forum for redressal of grievances of the consumers in accordance with the guidelines made by the State Commission. First up, moreover, comma, any consumer who is aggrieved by non-redressal of his grievances under subsection 5, comma, may make a representation for the redressal to an authority to be known as ombudsman, comma, to be appointed or designated by the State Commission. First up, hence, comma, the petitioner's remedy lies in the present case, comma, it is submitted, comma, before the ombudsman and not this court. First up, next para, learned counsel appearing for the private respondents next relies on regulation number 53 of the WBERC, comma, clause 14 of which stipulates the effect of splitting of load. Full stop. It is argued that in the present case, comma, since the petitioner seeks a new connection for the purpose of splitting of load, comma, despite using the previous connection at the premises, comma, the said provision comes into force and the electricity connection cannot be given in the name of the petitioner. Full stop. Next para, learned counsel appearing for the CSC Limited submits on instruction that the electricity connection at the premises in question is still live, full stop, still live. Full stop. However, comma, the same is standing in the name of the erstwhile consumer, comma, who is the deceased mother of the private respondents. Full stop. Hence, comma, the CSC Limited is required to remove the said connection which is continuing in the name of a deceased person and is agreeable to give the new connection to the petitioner subject to the previous apparatus being removed. Full stop. Next para, upon hearing learned counsel for the parties, comma, it transpires that there is no dispute as to the petitioner having purchased the property in question and being in occupation thereof. Full stop. It is well settled that a person in settled possession of a property is, comma, within the contemplation of section 43 of the 2003 Act, comma, entitled to get independent electricity connection in her stroke his name. Full stop. Next para, insofar as the present case is concerned, comma, the CSC Limited is justified in arguing that the live connection at the premises cannot continue in the name of a deceased person and is required to be disconnected in terms of the law and regulations. Full stop. Since the CSC Limited does not have any objection otherwise to give a new connection to the petitioner, comma, subject to compliance of formalities by the petitioner.
Complied with all the formalities.
Subject to compliance na kore, since the petitioner has complied with all formalities, comma, there cannot be any issue from such end as well. Full stop. Next para, inasmuch as the arguments of the private respondents are concerned, comma, they have no locus standi to object to the petitioner's enjoyment of electricity in her name, comma, in view of the property having already been sold to the petitioner and the petitioner being the owner and occupier of the same, full stop. In that apart, comma, the argument of section 135 within bracket 1 within bracket small e cannot have any bearing in the present case, comma, since the petitioner is seeking a new connection, comma, which shall not be transcribed, which shall not be circumscribed by any prior electricity connection or the purpose for which such prior connection was taken. Full stop. Section 135 within bracket 1 within bracket small e only applies when electricity is taken for a particular purpose but is being used for some other purpose. Full stop. Since in the present case, comma, the petitioner is seeking a fresh electricity connection, comma, the said clause cannot be applicable. Full stop. The applicability of section 42 of the 2003 Act is also not acceptable, comma, since the dispute raised by the present writ petitioner does not fall within the ambit of those which are to be redressed by the ombudsman. Full stop. Next para, this is not a dispute of a consumer of electricity with the distribution licensee, but a dispute sought to be raised by the private respondents, comma, who are entirely third parties between the licensee and the consumer. Full stop. In view of the above reasons, comma, the petitioner is very well entitled to get electricity connection at the premises. Stop. Accordingly, WPA 12969 of 2023 is allowed, comma, thereby directing the CAC Limited to give electricity connection to the petitioner, comma, upon removal of the previous apparatus and disconnection of the previous supply in the name of a deceased person at the premises. Full stop. Next para. In the event the CAC personnel are obstructed from doing so, comma, it will be open to the said personnel to approach respondent number 5, comma, the officer in charge of the Boranagar police station to provide adequate police assistance in that regard, comma, at the cost of the petitioner. Full stop. Next para, the parties shall act on a server copy of this order without insisting upon prior production of a certified copy. Full stop. It is expected that the CAC Limited shall complete the entire procedure of removal of the existing connection and disconnection of the same, as well as giving a new connection to the petitioner expeditiously, comma, preferably within how much time?
2 weeks. And not padlock if in the meter box. Maybe
Within 3 weeks from date. They are not in possession, Mr.
She is enjoying only a flat.
Oh,
But the
acha,
rest
very,
of the
very,
flat is being
very.
enjoyed by
You are
the
right.
private
You are right.
respondents.
যেখানে আমি at the cost of the petitioner বলেছি মাধববাবু, সেখানে একটা লাইন অ্যাড করে দিন. It is further clarified that if any padlock or other hindrance is put up by the private respondents or their men and agents, comma, it will be open to the police personnel to remove the same for the purpose of giving access to the CAC personnel. Thank you. Our actors, appellate said together.
18.
My lord, I am for the petition.
Lordship, I am on behalf of the private respondent, Lordship. Lordship, in this instant matter, Lordship, my fair submission before your Lordship, I am paying for 1 week time because Lordship.
That is not a fair
No, why I am saying it, Lordship, because Lordship, the matter has been mentioned for inclusion in the daily list, but before mentioning and after mentioning, no notice has been served upon the private respondent. And Lordship, the another problem is that Lordship, the learned advocate on record on behalf of the private respondent, he is abroad, Lordship.
How far? Depends on that.
On a Sunday, he will come, Lordship.
Where has he gone?
Malaysia.
No time. Malaysia, no time.
On a Sunday,
the next bus. Malaysia. Come on, I'll take it up tomorrow.
Tomorrow, Lordship, tomorrow.
Tomorrow what?
21st.
Are you an active member of any party?
No, Lordship.
Come on tomorrow. On the prayer of
Lordship, Monday.
Monday. On the prayer of yes.
I'm appearing on behalf of the licensed company, but I haven't been served with a copy of the can. So
give a copy to.
Can There is no can, my lord.
Yes, so one application has been
Can is
filed.
the usual can. I'll make that could right now. What is the can for?
Can for lordship for the purpose of addition of a party. One party has not been added in this writ petition. One vital party has not been added intentionally.
Why intentionally?
Because lordship, if this party will be added in this matter, then lordship, cat will come out of the bag. Because lordship,
I don't have jurisdiction regarding cat.
lordship, actually, lordship, by strength of the force document, by strength
But if
of
they did it intentionally, why did they make
By
this
strength-
application? Why did they make this application for addition then? If they intentionally suppressed, then why did they make this application for addition?
lordship, one party has not been added, and lordship, which party has not been added? The owner has not been added, lordship.
But they have applied for adding him as a party. So why did they do that?
No, lordship, I have filed this application, lordship.
It's your application.
It is my application.
Yes, what about the owner being added? You have not given a copy to him.
No, lordship, I will serve, lordship. I will serve. Actually, advocate on the record is not available.
Acha, learned counsel for the private respondent seeks an adjournment till July 24, 2023. Fullstop. It transpires that no copy of Can 1 of 2023 has been served as yet on the writ petitioner. Fullstop. Let a copy of the said application be served by tomorrow on the learned advocate on record appearing for the writ petitioner. Fullstop. Next para, the matter shall be listed for hearing on July 24, 2023 under the same heading.
I'm deeply obliged,
Be
lordship.
served on the
Copy
license
of the writ
company.
petition. Please give a copy of the
No,
writ.
not the writ petition, my lord, the can.
I will serve. I will serve upon each and every party.
Acha, copy shall be served on the learned advocate for the writ petitioner as well as the other parties. Other party na kore as well as on the distribution license.
Lordship.
বুঝতে পেরেছেন তো মাধব কোনটা?
Deeply obliged.
Give 2 copies, please ensure that 2 copies are given.
Lordship,
Please
lordship.
ask your learned junior to give 2
Lordship.
copies.
I'm deeply obliged, lordship.
আর হবে original set?
Original said.
Any original side mentioning? Listed matter item number 1. Inox Air Products Private Limited versus Director of Industries.
Yes. Finish in 10 minutes, sir. You are manipulating these 330s every day when this matter is taken up. You are for the state. You are manipulating 330s, manipulating not to attend, manipulating this no adverse orders. So you have to finish today by 10 minutes. Yes.
Well, to recap, my lord.
No recap. Start from where you ended.
Yes. Directly, my lord, to page 58 for once. As I stopped on the last day.
Right.
Lordship, in this 9.4, as it has been categorically 3 types of industries that has been stated: export-oriented units, units exempted from paying VAT, CST, and power incentive units. But specifically for that particular part, if your lordship just take power incentive units as defined in WBIPS 2005. Therefore, it has to be read as a whole. Power intensive unit as defined in WBIPS 2005. Well, as I have submitted on the last occasion, as such that by the term definition, that definition is not available. It means to say that as described or detailed in 2005. Because this power intensive unit specifically emanates from only from 2005 notification. Thereby, that specific notification has to be read as a whole, and we cannot pick and choose anything as because there is no such word as a definition. There is no definition clause for this power intensive units. So therefore, power intensive units, whichever the clauses that when it will be applicable and under what circumstances it will be applicable for this particular power intensive unit that has been categorically stated, defined or detailed in this 2005 notification. And my lord, thereafter will be entitled to receive waiver of electricity duty without any ceiling for the number of years and also for percentage of waiver in terms of subpara 7.2 above, it is given prior to this. Now, my lord, thereafter the proviso comes. My lord, the second proviso is very important. Let me place the first proviso also. Provided that the quantum of waiver of electricity duty itself shall not be more than 100% of fixed capital investment.
Yes.
Thereafter, provided further that the power intensive units, my lord, will not be entitled to any benefit other than waiver of electricity duty in terms of clause 7.2.
Right.
Therefore, power intensive unit specifically stated in as defined in 2005, and thereafter they cannot take any other benefit other than the waiver of electricity duty. Therefore, power intensive unit has been classified to be a specific industry where these norms emanates from 2005, and as well as they cannot take any other benefits which is available to the general industry as large. Otherwise, in other industrial aspects, my lord, the entirety of the business or doing while proceeding with that, my lord, with respect to, as for example, VAT or CST, whatever it is, it comes to the exchequer of the state authorities. Now, but here in this particular case, it has been excluded from those two. If these three kinds of industries has been mentioned, power intensive unit cannot take any other benefit other than this particular unit.
Obviously, yes. Yes.
And that is why it has been categorized as a separate from these. And thereafter, my lord, the last line of it. However, in such case, benefit of IPA will not be applicable to the power incentive units. Now, IPA also, that means, Lordship, that has been also stated at page 55. It says 7.1. Industrial promotional assistance. That has also been excluded for this particular industry. May I place it? Industrial units under group B, C, and D, as it falls, and falling in scale 1, will be granted industrial promotion assistance, IPA. The total IPA for which an industrial unit would be eligible shall be equivalent to certain percentage of tax paid by the unit in the previous year.
Yes.
Value added tax shall be considered for the entire eligible period. Therefore, the tax that has been paid. Therefore, here in this particular industry, when it deals with only with the electricity subsidy, therefore, it has to be.
You are Mr. Ganguly.
My lord.
Yes, Mr. Yes.
It has to be from the any state-owned unit. Well, that will be my respectful submission. And thereafter, but if your lordship kindly takes up directly to page 127. Well, this why I'm pointing out this plot has also been allotted by the WBIDC, by the state authorities, through state authorities they have got it. And thereafter 134, well, the registration. At that point of time, this is RC1. There was no mentioning with respect to that from where he will obtain the power, and therefore it is a general application that has been granted. And thereafter, at page, my lord, (141), it comes that with respect to the RC1, it has been stated, my lord, at page 142, they have applied for DVC for power. It is their choice, they can do. They have taken from DVC. Now,
no, they said for this region, nothing else is available.
My lord, if that be so, in that occasion, my lord,
it's not their choice, they say.
My lord, in that occasion, my lord, what it happens that they will not get this benefit. That is the only issue. They may run the business. They could, if they are aggrieved against that, they could have come against that particular thing, that whether we are able to provide or that They have not pursued anything with respect to that. They have directly obtained from DVC. Now, there we cannot restrict them, their choice with respect to that.
Why do you say it's a choice? There is no other operator.
But doing a business, if they choose not to take advantage of this scheme, we have nothing to say.
No, they get advantage of this. I appreciate what you're saying. They are saying that there is only the DVC is the only power of the supplier there.
Admitted position.
See, if that be so, where is the option of going to someone else?
My respectful
If
submission
they had
is,
the option, probably they would have chosen to go to the WBSCT cell to
Yes,
get this incentive.
but my scheme
That is
says
not there. Yes.
that if it is not from me,
No, it's a larger issue. If there is no other option apart from the DVC, where is the question of applicability of this applicability clause? I mean, where is the scope of somebody drawing power from the WBSCB?
That's why.
Then it will be an exclusion of that entire region itself.
Particular region.
From this subsidy.
From this
What is the
subsidy.
basis of that?
My
Can there be a reasonable basis of that?
Therefore, the scheme itself therefore says that this is a general scheme that has been granted to the power industry, in particularly the power industry, but this is applicable if it is taken from these sources, and those areas which are not yet been catered by the state agencies, therefore it says that this is not a matter of right. That is why this has been stated categorically that where the provisions it will be is available, if they take the unit from the state industries, then only the duties that has been charged by the state can be waived by the state. The answer is that this is an incentive. We can provide the incentive on a reimbursement basis when they will pay, or they are supposed to pay, we can waive it. But the control with respect to that duty, which we are going to waive, has to be a part of our exchequer. Well, that is my respectful submission. The issue is that if it is not available with the state itself, we cannot take the call that whether to give a waiver or to give grant a subsidy. It is available only in case that we have a control over it, because my duty I can waive. DVC's duty I cannot waive. It is not within my power or control. That is the moot issue, that what we are pointing it out, that the entire 2005 Act, that is why this has not been replaced. This Act replaces, notification replaces,
So are you meaning, Mr. Ganguly, that if they take from some other distributor, if they take electricity from some other distributor, they're paying the other distributor, so the state has no scope of giving any subsidy there? Because you are adjusting with this with their payments if they are drawing from WBSCB.
Yes, either
if they're not drawing, if they're drawing from WBSCB, you could have given certain price cuts probably or some other subs. Are you arguing that if they take it from some other distributor, you being the state, you do not have any scope of giving that financial benefit to them because you are not paying them?
Why?
Rather,
Because
they are not paying you.
2005 is the guiding principle.
But you are the state. State can always give that subsidy and has to reimburse in some manner or compensate the distributor in some manner. That is the concept of subsidy.
But this distributor itself,
yes,
is not within the control of the state authorities. Why? Because 2005, that is why specifically states that either from this Durgapur Project Limited or...
I'll give you an example, an analogy. Maybe not a very good analogy, but suppose you give some incentives, the state gives some incentive regarding small scale industry. Does that necessarily mean that it has to do business with the state itself only?
In that case, this is the general proposition. But
no, there also you are paying. They are paying you, suppose.
They are paying with respect to VAT or sales tax or authorities.
That always remains in case of these sectors also.
But
they are paying certain taxes.
But with respect to the power incentives, this scope has been limited by the notification itself by referring to 2005. 2005.
Power intensive is on the power intensive, the consumption of power, the nature of supply on that. Now, power intensive is a definition of the technology, not a definition of the operator, of the distributor. I mean, this is an applicability. Page 114 enumerates an applicability. It shall be applicable when you take from West Bengal WBSCB and such and such. Now, the purpose of that scheme itself, that also clarifies at page 108 that this is for new, expanding and sick and closed industrial consumers of DPL and WBSCB.
All. but of WBSEB.
DPL and WBSEB is the basic preamble of the notification of 2000, but that does not operate in this the present one.
Well, the present one specifically refers with respect to the incentive duties by saying that as defined or
But
detailed.
not to the WBSEB. The preamble of the 2005 scheme that refers to the DPL and the WBSEB, that being one of the purposes, granted concessional power tariff for new such and such industrial consumers of DPL and WBSEB at page 108. But that rider is not there in the 2014 scheme, page 48.
Well, there, what
Here
has
the
been
scheme is for a different purpose.
Well, but 114, if you actually kindly takes up the applicability, it states
Rather, here at page 48, Mr. Ganguly, it is for the specific purpose. Its purpose is for extending certain financial support by including more industrial units under its jurisdiction, with a view to promoting large-scale industries and industrial atmosphere in the state, which cannot be restricted to the WBSEB.
well, why I tell you, Lordship, well,
It's inclusive, more industries. That means more than the WBSEB consumers and others.
absolutely the general concept of that. But
Yes.
well, this, what troubles is, well, this categorically says that as defined in WPIS 2005.
That is the only thing that is troubling.
Yes, because that it says that with respect to the power intensive units, it has to be as per stated in 2005.
As defined in 2005, which does not define at all.
Well, it defines the entire scheme of the act. Well, we have to rate it as a
Why do you refer
scheme.
it back to some scheme where it is defined, the definition in a scheme where it is not defined at all? Why do you do this?
Well, this particular aspect, my lord, has not been challenged, that this wordings or something, that it is not the widest of this is challenged, my lord. This, as we get it here, my lord, we have to follow that one, that it as it is in 2005, because the scheme says the eligibility, my lord. It has categorically mentioned the word eligibility, that is thereby limiting the scope to that one. That is with the state authorities. Now we are saying that even if it is with any of the state authorities, WBSEB or any other state authorities, therefore we can extend. Well, that is the main gamut of the submission.
Let me hear Mr. Kavitan
Well,
on reply. Yes, please. What do you have to say? You have no locus standi here. Oh, your DVC is here, right?
I made them.
Yes. I'm sorry, Mr. Kavitan, please take it. Yes.
They do not collect any electricity because the electricity is supplied by DVC. When the duty is collected by DVC on behalf of the state, and in terms of the benefit,
Yes, they collect left and right.
if we pay,
And if possible from the middle also.
the state.
Obviously, yes.
The prayer has been made the application directing the respondents to refund balance. We have already collected and we have already paid to the state. So when a DVC does not have any responsibility for refund any. That's
Oh, very, yes.
If my lord is pleased to look at that scheme of 2005, page 108.
Yes.
My lord, if I may draw attention to page 109. The last two.
Yes. Yes.
And whereas the state government has decided to provide incentives to power intensive units to new and expanding industry in certain designated areas by way of reimbursement of part of the net energy charge for a certain period by the state government as per details formulated in part B of the scheme. Now, therefore, the governor is hereby pleased to hereby approve and sanction incentive to power intensive industries located in West Bengal as per scheme detailed below. So it was a net energy charge. Now, there's a distinction here. Then we'll kindly see page 110.
Yes.
Paragraph 2. The scheme shall come into effect on 1st April 2004 in the whole of West Bengal and shall remain valid for a period of 5 years or 31st March 2009, whichever is earlier. So it is not that it's a continuing scheme. My opening submission was that is a discontinued scheme. And not it is only the definition which has been taken from here. Now we'll kindly see at page 112.
Yes.
Energy charge is the product of actual energy in kilowatt hour drawn during the month and gross energy charge per rate as per prevailing tariff, but excluding demand charge. Net energy charge is the energy charge computed after allowing rebate on energy charge as approved by the West Bengal Electricity Regulatory Commission from time to time. At present, such admissible rebate is 4% for 33 kV and 66 kV supply and 8% for 132 and 220
kV. So, my lord, they have defined this charge. If my lord is pleased to my lord, take volume 2, page 267, my lord, there's a bill of DVC. My lord, it will show what these charges comprise. They do not include the electricity duty at all. So, my lord, the electricity duty comes after these charges. Then, my lord, at page 114, B.7.1, state government through its authorized agent will offer incentive in the form of reimbursement from the state government to all new units or expansion of existing units in the districts falling in group B and C areas. So what D was not here at all. Not B. As defined in West Bengal Incentive Scheme 2004, drawing power through HT 33 kV, EHT above 33 kV connection having actual monthly maximum demand of 1500 kV and above on the net energy charge. So, and then the table shows how much of the net energy charge will be given as incentive. So, this net energy charge did not include the duty at all, but it was the charge for the electricity. Therefore, this scheme provided that a part of the energy charge will be given as incentive. So, unless the state undertaking collected the money,
had to be linked with the net energy charge.
Yes. So, and therefore, I was collecting. My learned friend argument was that I have to collect, then only I'll give back.
Yes, yes.
So, here it was so stipulated because they must first collect the energy charge. So, the energy charge will be collected by the board, and therefore they are in a position to reimburse. But not what we are talking about. Our scheme talks about electricity duty. Electricity duty, my lord, is not to be mixed up with the charge. As I submitted, my lord, in the invoice, my lord will find at page 269, volume 2, that is a separate charge imposed as a West Bengal electricity duty. It is different from the
DVC is taking that amount from you.
Yes, my lord. Page 267, my lord, a sample invoice is there, and that will show, my lord. Well, kindly see the middle of the page.
Yes.
Details of bill. Energy charge at 470 paise per kilowatt hour. In the middle of the page, the third table.
Third table, yes.
Energy charge on the left hand side. Energy charge at 417 paise per kilowatt hour.
Yes.
16
Yes,
lakhs.
duty is a separate column,
It is
separate row
and
altogether.
It is a West Bengal electricity duty. Now that regarding electricity duty, I got the bare act. If my lord is kindly please have a look at.
Thank you.
But kindly take note page 5. But there's a printed page note. Kindly have the printed page 5.
This energy charge and duty cannot be equated. How can it be?
It cannot be.
That's a charge and this is a duty payable to the nature of a revenue.
In fact, duty is levied on the energy charge. That's what the Act provides.
Yes.
2A energy charge, definition at page 5. Energy charge means the amount charged, whether as energy charge or some other charge by a licensee for the supply of energy to a consumer before deduction of rebate, if any allowed by the licensee for payment on or before such date as may be specified by the licensee. Then on the next page, 3A net charge means the amount of gross charge that remains after deducting therefrom any rebate referred to in clause 2F or refund of fuel surcharge, if any. Then with the charging section 3. Subject to the provisions of subsection 3, there shall be charged, levied and paid to the state government a duty referred to as electricity duty on the net charge for energy consumed or the units of energy consumed as the case may be at the rate specified in the first schedule. So therefore, it goes to the state government.
Obviously, yes.
Therefore, the state government said that we'll waive it. You set up and we'll waive it. So the other submission.
In the 2005 scheme, it would be directly adjusted with the consumer, and in the present scheme, that has to be adjusted between the DVC and the state.
Yes,
apparently,
because that duty will be collected.
Yes.
If my lord is pleased to have
but they cannot collect it from you.
No, it goes from me to the DVC.
How do you get the subsidy then?
That is the mechanism. They will follow. They may inform DVC that they are not to charge me the electricity duty because under the scheme it is not to be. It is waived. Or they will otherwise not refund it to me. Either of the two mechanism they have to follow, because
in the present writ petition, Mr. Khaitan, you have also claimed for refund of the amount charged by DVC after the coming into force of this.
yes, I have mentioned the figures, because every month I'm having to pay. I cannot afford not to pay because they'll cut off my electricity.
Disconnected. Yes.
So I have had to pay, but I'm on the principle here, because once the principle is cleared, then they will have to process it. I cannot really say, because they may not have checked the amount, etc. They will do that, but the principle in my humble submission should be laid down. But just one aspect, in my lord, just please similar page 48, where the scheme starts. I will draw attention to paragraph page 52, paragraph 4.
Yes, 4.
Non-applicability of WBSSIS 2013. So this, if they wanted to exclude entities which are taking supply from DVC, they would have said so. There's no such exclusion here. Malan friend says that whole 2005 scheme stands adopted here. In my humble submission, that the applicability clause for that scheme does not stand adopted. The applicability clause is all here. I fulfill it. They cannot import the applicability clause of that scheme, which is discontinued, for the purpose of implementing this scheme. And the other thing, I just wanted to show that my learned friend drew attention to that letter of West Bengal Industrial Development Corporation. Kindly see at page 113. I'm sorry, I'm 132, 127. 127 it starts.
Yes.
But it's dated 4/11/2016.
Right.
And if I may draw attention to page 132. But
132, yes.
3.3.82. Electricity. Temporary power connection can be taken from DVC, WBSEDCL, WBSETCL for construction purpose only. However, for commercial operation, the company will have to apply to DVC, WBSEDCL, SETCL. Power will be supplied directly by DVC, WBSETCL, and to be taken through underground cable. So it was left open to me. They allotted the land. They said, and then there's nobody else would supply me that power. In my progress report, with my land friend correctly pointed out, I had mentioned that I've applied to DVC for the past. It was a fact on record. There's no, it's not that something was, they were not.
Mr. Khaitan, suppose you win, what could be the alternative modality of their not refunding? What could be the alternative?
As far as the duty,
the one they have collected, they have to repay.
Yes, that they have to. That they have
the subsequent ones, yes, a modality can be formulated by state or whatever.
Because that is a sum which has already I've parted with.
But the rest of them, you cannot be charged with electricity duty. Are you saying that? Or you can be charged with electricity, but they have to reimburse in some manner.
The word is waiver. So waiver.
Waiver, yes.
Waiver means that they should not be charging.
True.
But I have been they have decided this application by simply saying that they've not gone into the figures. So there's also a claim for interest. Now, in my humble submission, they have to first decide the figures, then the quantification will happen. So in case my lord is pleased to hold,
the principle has to be laid down either way here.
Yes. And those aspects can then be urged in the department.
Maybe yes. Thank you so much. Arguments are concluded. The matter is reserved for judgment. Yes. Thank you. Thank you, Mr. Ganguly, in particular, for finishing today.
Whatever falls from your lordship, we are bound by it.